Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020, 7:44 p.m. How, does the FBI find people, and people is misspelled P-E-O-O-P-L-E. Did the defendant find out how the FBI finds people in this case? Oh, she found out.
Oh, I completely butchered that one. Hang on. There we go. The real question is whether RA is going to be right on time or whether he suffers from rob time. Time's a construct, right? Time's a construct. I was on time by my clock. Does that count? It might be a tiny bit late. Rob, thanks for being here. I also have to give a huge shout out. Thank you to Lee. Oh, there you go. It helps if I'm on the screen too. Lee is actually one of our dynamic duo. Lee and Shell's a husband and wife team. One of our other court watchers who've been helping us out on some other trials, been able to observe some trials and report back to us. Thank you very much, Lee. Today, you're first in chat, which means you own the internet. You're responsible for taking care of everything IP related worldwide. So if you have any troubles, anybody, just go ahead and reach out to Lee. He'll be right on it. Very capable, by the way. Very capable. He'll be able to fix it. Also, many gifters gifted memberships there during the little break, and thank you for that. Allie Upton, welcome to the gallery as well. Thank you. It's wonderful you can join us as a new member. Please make sure you take a seat by typing ! seat in chat. We are getting set for this afternoon. Oh my goodness, we're ready for the jury, right? KF says, "Okay, I'm ready for this jury." The jury has had all lunch to think about the witness they just heard. That took a grilling from Mr. Anderson, a very long grilling, with by my count about 24 minutes. But I think Mr. Anderson was very effective at discrediting this witness in the minds of the jury. But I don't think the jury's done with that. I think they'll want to have their say as well. I cannot wait to hear what the questions are. So those will be coming soon. Let me get all our feeds prepared so we don't miss a thing. The judge says, I think they're coming back in about 11 minutes or so, 12 minutes. 1:15, so 13 minutes. Sorry, I can do math. It's hard, but I can do it. So we're coming back soon, so we can answer a couple questions for you if needed. I realize I did not sing happy birthday to anybody this morning. I did the hump day cheer, but I think we have a couple birthdays. Is there anyone in chat that absolutely needs their birthday celebrated appropriately? And it's not just me singing. It's all of you singing. I just happen to be leading the group. So I sure hope everyone is singing along with me. Squirrel. Yes, we do have sounds turned up right now, which means they're all going to be triggered all at once. So you'll see some commands in chat. Usually during testimony, we have sounds turned all the way off, so we can just pay attention to the testimony. But we have some commands that you'll see members and just people in chat, all of you, any subscribers have access to.
Don't miss the forest for the trees.
Like that one. Let's see. Ariel gifted a membership as well. I realize you guys are trying to target certain people that have missed or are deserving of a membership. I wish YouTube would allow you to gift a membership to a specific person. But Janet Hill is the recipient on this one. Congratulations, Janet. And thank you very much, Ariel, for gifting that. Very generous, all of you. So thank you so much. I didn't see, let's see, Mama Bear had a birthday and Pi Lisa. Let's sing. And by let's, I mean all of us. Let's sing together to celebrate the birthday. One verse. It's going to be Mama Bear and Pi Lisa. La 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 la. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, Pi Lisa and Mama Bear. Happy birthday to you. I switched them up a little bit on you guys, so that's why I heard you guys sing Mama Bear and Pi Lisa. I did hear everyone who was singing. It sounded beautiful.
I'm confused at who is charged for jury S.
Happy birthday to both of you. Hi, Lisa and Mama Bear. Thank you so much. We got a comment. A question just came in right there. Let's see if we can listen to that one and respond. Happy birthday. Yeah, that wasn't it. But let's see. Anita Carroll says, I'm confused. Who was charged for jury questions? Anita, that is a great question. Sorry, I had to go there. That we've heard that phrase a lot from witnesses when they're asked jury questions. But the question of who is charged for the jury question time is what's the factor here. And the judge has said that he's splitting it between both parties. Now, that was what he initially said, but then after the jurors had taken a lot of time, he refunded the time to both parties. So both things have taken place. The court has sort of just eaten that time on their own clock because they refunded it, and at other times it's been charged to the parties. So I don't know exactly how it's going to end. I think it's still being counted towards the parties, and there might be an attempt to get some of that to sort of claw that back. But that's where we're at with that one. So if you're confused, you're not alone. We're all waiting to see. Rob takes a break from trial prep, and gives some more memberships. Thank you very much, Rob. Appreciate that. Was I on time, Rob? Does it count as on time? By my clock, I was within the 1 o'clock minute, Eastern time. Always incredibly generous, not just with the gifted memberships, with his praise and also just sharing his community with us. Thank you so much, Rob. I appreciate that very, very much. And you have your work cut out for you, by the way. I know you've got trial, but you're going to have a huge recap coming up with this witness. It's going to be wonderful. I cannot wait to hear how that goes. All right. Gifted memberships all around, apparently. Cheers to everybody that won. Rob is the bestest. Thank you. We are, let's see. Someone was asking if I am in chat. Oh, that was an old message. Never mind. I am in chat, but I'm also here. I'm actually here. Let's see. We've got court. We're set up to listen in right now, and we just have the judge's door. So we're good there. We'll have that as soon as something happens. Let me go ahead and bring a couple other feeds on. I'm going to connect to the court Zoom feed, which occasionally has audio when the other feeds do not. And that this usually has happened when there are juror questions being discussed, and for some reason the audio team leaves the sound off. Now the sound is on in the courtroom. Everyone's able to hear just fine. But the audio team that's transmitting that to the feed has turned theirs off. So I'm going to try, if that happens again, especially with this witness, I'm going to try to listen on my phone, which is listening on Zoom, and recount verbatim everything I hear to you guys so you can hear the questions, even the ones that don't get through, because that is a nice indication of what the jury's thinking. So we're going to try to do that. And so if I put my phone to my ear and start talking, that's what it has to do with. All right. Unfortunately, I can't talk and work a phone at the same time. I can do two things at the same time, but talking and typing is not one of them. So hold tight. Here we go. 12th. Connect. It's a long sort of process to get there, so I have to go like 6 different places and agree to all sorts of rules and conditions. Then open. All right. Register. Agree to the terms, and now we're in. Okay, so now we're in the Zoom. I'm seeing right now that the defense attorneys are just now filing into the room, so they're just getting set. So we should have some action in the courtroom shortly. Let's see. Mathis Grease says, "Nurse, I don't know if Maya would have a problem with being forcibly stripped and photographed. How does someone hear that and not vomit with rage?" That was their shining nurse, the perfect nurse who just is there to make everyone happy, and on cross-examination would not give an inch to the plaintiffs, and would not even admit that would have made Maya uncomfortable. Even though she knew Maya and she had been there, she'd been the one holding the curtain, the sheet, holding the sheet up so Maya would have some privacy in her room with the door closed and the blinds closed. She knew that Maya was that private. She was that conscious of her modesty that she would hold the sheet up so Maya could change behind it and then say, "Okay, I'm done." And then she could, they'd put the sheet down. But she would not admit that being forced to strip down like that and be photographed would make her uncomfortable. And that's where the jurors disregarded everything else she had said. It was, wow. Anyway, crazy time. Let's see. See Squirrel Whisperer comments. Kim, let me see what Squirrel Whisperer said. Sorry, let me scroll up just a bit. I apologize. Chat's going really fast. I'm really trying to read as many as I can, but I'm not seeing it. Can somebody copy it for me and repost it? I'm just not seeing it on the feed. Let me know. All right. Okay, I see Mr. Anderson's back in the room.
Are we going to address subject matter jurisdiction?
There's Mr. Brooks. That's one of those sound effects. We'll turn those off when court starts so we don't distract from that, but we do like to have a little bit of levity in the meantime. The witness, Anderson, looked angry at the defense lawyers, like he anticipated this, and the lawyers reassured him. F-Cart, I did see the witness. I wouldn't say, I didn't pick up on the anger part. It might have happened. I was probably reading chat at the time. But the witness, Anderson, who is still on the stand, and will be back on the stand, possibly for more questions on cross from Mr. Anderson, the attorney, or possibly just from the jurors. But there were many times when he was sort of caught with the question, and while floundering and stammering for an answer, would glance over at the defense
Disabled
table.
Vet WCRPS
as
loves
if to
this
plead
feed
for
chat
help.
and RA Red Heart.
Beach Lover 64, Disabled Vet with CRPS, loves this feed and chat. Thank you so much. Thank you so much. I appreciate you. And first of all, thanks for your service as well. Appreciate that. Thank you for the generous super chat. Debbie Seltman, welcome to the gallery. You'll have to tell me your profile picture is that the treble clef? I didn't study that well in school. I do play the guitar a little bit, but not very well. But I'm curious what you do with music. Do let me know in the chat. Did an attorney get sanctioned? Lacian, not here. That hasn't happened. I don't think that would happen during court. That would be probably separate. But there's some issues that came up that seemed like this should not be happening. The discovery issues this late in court, that should not be happening. But at the same time, this is an enormous case. Tons and tons and tons, reams and reams, boxes and boxes of documents. And could they miss one? It's possible. But in this case, it seems a little bit more intentional. Like, hey, we don't want you to have that, so we said it didn't work. It wasn't there. The judge just said it needs to be transferred over. We'll see how that goes. Is Rob going to be in the trial that we can watch? I don't know. I bet he probably... I'm just guessing because Rob's here. He can answer for himself. But I'm guessing he'd probably be like, no, that's good. You guys focus on something else.
Congrats on your 1 year on the tube. Love it here.
Megan Easton, thank you very much. I'm super excited. This has been the best job ever. I mean, I've liked my other jobs before, but I've never loved waking up every day and going to work like I do now. It's because of you guys. Thank you so much for this amazing community. Can I get a short recap of what happened? Miku's headphones, it will go like this. And if it's okay, I'm going to act it out. Is that all right? So this is the defense, and this is their plane, and it's like, it was like that. I think that pretty much covers it. No, that being said, they had some great testimony from a couple really good witnesses. The nurse, Jules, reported and says, it looks like the jury really likes this nurse. She said that, I think, before cross. So I'm not sure if that changed. But they had great witnesses that said all the right things, but on cross-examination, things started to fall apart. And another issue that the defense has is that some of their witnesses, even though they say good things, but they don't match up with other witnesses they have, with other doctors, with other evidence that's admitted in before the jury for deliberation, or will be. It's an issue. It's an issue. There's a lot to cover. I don't think I can recap the whole thing, Maikus, but I would recommend, this is one, a lot of times I say, we'll just catch you up and keep going, but this is one you might want to rewatch in the morning. I think it was phenomenal, especially the closer we got to lunch, the better it got. Please put up objection counter, please. I can do that right now. Let's see. There's our objections. And, oh, look, I'm on the screen twice. Okay, there we go. Let's bring in the courtroom view as well.
What more do you need to see?
That's not it. There we go. All right, too many sources, too many videos. We are also, for those that are interested, we are still recording the People versus Woodyard trial out of Adams County, Colorado, and that will be posted on our other channel. That channel is called Topmark Media, and we're posting that just raw WebEx video of the trial, the entire proceedings, gavel to gavel. So that'll be posted over there. Those will be going up tonight for today's proceedings. They did not hold court for the last 2 days. That's why there was nothing over the last 2 days. The counter has to be up on the screen. I got it. Sorry, I just barely caught up with that. As far as where everyone's guesses are as to where they thought we would be.
Jurisdiction?
Hang on, there we go. Okay, we're at, I think the person who's winning right now, let's go back here. We're at 1381. So we've got Greeners right now is in the lead. He's the closest. And then 1384 is next with Everayan. So that's coming up soon. Megan S., welcome to the gallery. Thank you so much for joining us. Appreciate that. Thanks for supporting us as a member, and help yourself to the emojis. Okay, I'm going to turn the sounds down so we can focus on court as it's about to begin. I think we're a minute late. The judge just walked in on the Zoom feed, so any second now we'll get the video. And let's see, we need that and that. Pardon the trumpet sound, as my kid has found a piece of PVC pipe and figured out how to make it resonate like a tuba, and he's walking around my house doing that constantly. Love it. Miss Christie, thank you so much. Thank you to every one of the 44,000 subscribers.
Sure.
It means
we
the
would
world
like
to
to request the standard jury instruction 601.2 be given, which it is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited because the witness talked with the lawyer about his or her testimony.
I assume you mean for me to do it right this second as opposed to,
yes,
or in addition to,
yes,
the end?
Yes, that's the request, given the implications raised by Mr. Harrison.
I think I can just do it at the end. I don't think it's appropriate to do it at this moment.
Okay. All right, then do you want to do exhibits, Judge?
I am.
Oh, great. Do you mind if I sit?
That's fine.
Okay. So we would like to look at 3227, 144. This is an Instagram photo taken on February 9th, 2016 and posted by Maya.
3227, what number?
144, 0144.
Can you pull up, please?
Yeah, February 9th, 2016.
Objection, relevance. I think we faced a number of cumulative objections for trying to introduce those in Maya Kowalski, so I'm not sure what this adds to the case.
Well, if I need to respond, I can, Judge.
Sure.
It adds several things. One, it is 3 days before she is in Dr. Barr's office saying that she has pain that is like fire throughout her entire body. Secondly, it shows that her ears are pierced, which goes to several people testifying that piercings would cause pain with RSD. And it shows no lesions on the skin. And I don't think we've put in many photographs at all yet.
It does nothing to establish if she had her ears pierced recently or this exists. I think it's since she was 4 or 5 years old, so not sure what that adds.
And I don't think touching her earring is particularly painful.
The court will receive into evidence 3227-0144. But let me ask you this. All of this metadata at the bottom.
We can delete that. I want the date on it, but we can delete the metadata if you want.
I mean, does the plaintiffs care? I just want to
Right, we did delete some of it, but I'm happy to delete all of that, Judge, as long as the date remains.
We don't have any objection to the metadata.
Okay. The next one would be 32270135. The significance of this photo, Judge, is that this is the day after she's in Dr. Barr's office saying that her pain is like fire throughout her body. I think the jury should be able to see the photograph the next day, which would indicate no, plus there are no lesions visible on her skin.
Objection.
These are
That's
Instagram
not the
photos?
purpose. They are going to attempt to make the jury believe, I don't know what about Maya in that pose, but we assert 403 on that. Any probative value is far outweighed by the prejudice of attempting to show this young girl as anything other than a young girl.
Judge, this isn't like surveillance. This is a photograph she took of herself and posted on Instagram. It's the day after she was in a doctor's office telling them she has pain throughout her entire body like fire.
The court will receive into evidence 3227-0135.
Thank you.
Did anyone see if the metadata on the bottom, did it show there was a filter used on that image at all?
3227-0485. This is taken on April 23rd, 2016. Shows her wearing a metal bracelet around her wrist and her hand and no lesions.
This one's filtered 0 normal.
Don't we all cumulative, Your Honor? Don't we already have not only testimony but other photographs?
Okay, I'll let this one in, but Ms. Quarles, we're getting to the point where
That's fine, Judge.
I mean, we almost have a family photo album of probably about 40 or 50 pictures by now.
I did try to pick different dates, Judge. I do have one more along those lines, though, that I'd like the court to look at.
Sure.
That is 3227-0441. The significance of this photo is that this is July 16 when she's in a wheelchair. You can see that she is sitting on the edge of a table of some sort, raising her left leg. And this is when she is in a wheelchair.
Objection. This is again cumulative to about 7 or 8 other photos and indicates what? That she can sit in more than a wheelchair? What is it probative of other than just some kind of prejudice about the... I don't understand.
This is when she's in... Is this when she goes to the hospital? This is during Dr. Hanna's treatment. She's in a wheelchair, supposedly. She can't move her legs. This is a photo taken on July 16th, 16. She's sitting with her own body without any support on a hard surface, not in a wheelchair.
Don't we have video of her playing around in the pool and demonstrating her upper body strength based on the ketamine infusions and based on where she was with her therapies?
I'm going to let in 3227-0441.
Thank you, Judge.
And cumulative, by the way.
I listed this one.
Yeah, I don't think there's been any claim that ears are extremely painful. Ella, good point. The ear piercings, there's no, to Mr. Anderson's point, there's no testimony as to when she got her ears pierced as well.
Are you able to play that?
Okay, that scared me to death.
Cumulative to other ones, and does not demonstrate anything other than what is already in the records. Yes, she can play the piano.
Well, the other piano one was not during the admission of the hospital. I don't remember the date, but I know it wasn't during the hospital because it was at home.
Yes.
I'm going to admit, what number is this?
3089.
3089, the court receives.
32320819.
3232. Let's go ahead and put it up, whatever it is.
It's a blog by Johns Hopkins, dated 8/10/2015. We were going to redact the comments above and below, Judge. I thought that had been done, but so it would start at user Beata Kowalski, and then the text, and then the date at the bottom.
Didn't I just let in yesterday a whole series of emails from Beata Kowalski over any number of dates?
Those were all about the coma. This is
well, no,
August 10th.
I mean there were lots of them because they went not only during the November of 2015, but they went all the way almost in 2016.
Let me take a step back from that, Judge, and look at what was admitted before we go to this.
Because I mean, there's a cumulative issue.
Yeah.
I let in a whole bunch of them.
All right. Let me see if I can find that, Judge. Okay.
Well, if you're going to cry, I'm not going to.
I think
Judge,
he's talking to Mr. Whitney.
I'm sorry?
He is.
Yes, we're talking about.
Sorry.
Very mad at me. I didn't ask questions. Do you want to?
Okay.
Never mind.
It's just, if you all want to talk to each other, you really need to push the silence button. And
I understand.
I mean, we all hear.
What do you do?
When you know
Including the jury.
Yeah, including like doing this with your fingernails, like I just did, and all sorts of other. Moving the microphone like that doesn't really do it. You need to hit the mute button.
Little courtroom 101.
And hold on to it when you want to have that discussion. I see the TV gentlemen probably would be very happy if you did that.
Yes.
He's shaking his head yes.
Yes, sir.
What's next, Ms. Crows?
Judge, we would like to revisit 31389. That was the Tribeca Film Festival, and I'd like to clarify with the court that the photo you left in at 7 was from 2022. We removed all references to Tribeca, so it is simply the 2023 photo we have. The previous one of her with her boyfriend is from 2022, where it looks like she's going to the prom or something. If you can see, we've removed all references to the Tribeca Film Festival. That was the prejudice that was claimed.
They edited the background.
It is a 2023 photograph of her with her boyfriend.
I maintain my ruling on 3138-009.
I'm sorry?
No, I'm not reconsidering. It's not in.
They literally just photoshopped that one.
Yeah, Judge, I think that's our only 2023 photo.
She's like, but it's our only 2023 photo.
Right?
The argument, the discussion with Mr. Anderson, Mr. Whitney had.
The jury has seen Maya Kowalski here.
They had.
I'm just saying.
They had a discussion.
I think the testimony of Maya Kowalski with respect to her life has been dramatically. Yeah.
Mr. Anderson had told Mr. Whitney, well, you can cry about it if you want. Basically saying, if you don't like the questions I asked, go cry about it.
To his house, they don't do anything. I'm suggesting, Judge, that in fairness to the defense, we should be able to present other aspects of her life that have not been testified to in front of this jury.
Tribeca film photo is out.
Okay.
For the third time, that photo is out.
Close to 1:30.
Okay. All right. Well, there's nothing else that needs to be confronted today, Judge.
Anything else we need to talk about? Witness, Mr. Anderson, before we bring him in?
Judge, we would move to strike the opinions having to do with standard of care based on 90.704703 on the fact that from the evidence, the witness conducted virtually no independent analysis of the evidence in order to render such opinion, and therefore both the foundation and the predicate of this were lacking, and thus there was no basis for those opinions rendered.
And we'd like our time back.
I think the jury can make the determination based on the questions that have already been asked, and I'm sure will be asked.
Yes, sir. Only other thing, Your Honor, is...
so we're back to tag teaming again?
No, I'm not arguing the issue.
Oh.
I'm bringing up witnesses for tomorrow. We only know Dr. Scott Smith.
Nurse Alicia Alcida.
The nurse that assists with the photographs.
I'm not sure
Sally
I'm
Smith.
saying her last name
I know who
correctly.
you're talking about. And who else?
Those are the only two live witnesses, hence the need for depositions.
Understood. And we're done designating Dr. Hannah counter-designating, so.
Nurse
So
Alicia,
at some point,
Sally Smith tomorrow.
When do you think I will be able to receive the objections? And I might or might not. Did someone send the actual deposition over? I know I got something for Dr. Hannah a few minutes.
I'm sure they weren't highlighted, Judge, with designations, if that matters. I don't know if you need it highlighted. We're just going to give you our objections.
I just need what I'm supposed to rule on and the
Okay.
deposition, hopefully the full-size deposition, and I'll take it from there.
Okay.
But I just need that information.
Understood.
Yeah. Anything else about anything before we bring in the jury?
No, just procedurally, Mr. Anderson, are you done with your cross?
I am done with my cross.
Just a couple minutes of redirect, and then we'll yield to jury questions.
Okay.
Tomorrow's going to be absolutely
Let's
crazy.
bring in the jury. Let's go get witness, Mr. Anderson.
As will Monday. All right, the jury's coming in now. We're just getting set. Let me switch to this feed briefly while I get everything synced up. Ella Cole sends a super chat saying, "I'm seeing a lot of pretty prejudice, regarding how much pain Maya was in. It's a thing. Shouldn't be, but for some reason, to my minority, if you're attractive, you're fine. Defense is giving of ick." I struggled with that one, Ella. Like reading 101, I struggled, and I apologize. Thank you very much for your both your generous super chat and for the sharing the comments. The defense is trying to admit a lot of pictures that make it look how happy she looks.
Members of the jury,
like
I want to
painting.
confirm while you were away, you did not discuss this case amongst yourselves, you did no investigation, and received no information. Is that all correct? Correct. And no one approached you about this case. Is that correct? Correct. And you did not see any media coverage about this case. Is that correct? Correct. Mr. Shapiro, it's your turn, sir.
Mr. Anderson, just to clarify the sequence of events, last night you and I met. Is that right?
Correct.
Okay. You gave me your opinions.
Correct.
And then I discussed with you what topics I'd like to cover in front of this jury. Is that right?
Correct.
I gave you an outline of the topics that I wanted to cover. Is that right?
Correct.
I didn't tell you what the answers needed to be, did I?
No.
Okay. The answers that you're giving to the jury today are your own.
Correct.
Objection. It's bleeding. Let it go a little bit.
So staying on this issue.
Okay. The answers that you gave to the jury, where did they come from?
They were from my own experience and my own observations of the data that I read.
Okay. And I know that at this point in the trial, you're one of several experts that the jury has heard from. But in your experience serving as an expert, is there anything unusual about meeting with the attorney the night before?
No.
Okay. You were asked about a performance review of Miss Betty. May I approach the witness with the document?
Show it to Mr. Anderson.
Yes.
Attorney Mr. Anderson, I should say.
If I may approach.
Yes.
And take a moment to read both pages, if you wouldn't mind, Mr. Anderson. Is this the 2-page document, the full document that you had discussed with me earlier about you being aware of one verbal write-up?
Correct.
Okay, so I had provided that to you before testifying.
Correct.
Let me ask you this. In reviewing the document, does that show any impropriety with another patient, or was it employee to employee?
It was employee to employee.
You were asked about any notification from the family about Miss Betty's conduct. Do you remember that testimony? Mr. Anderson had asked you if the hospital ever received notification about the family complaining about something Miss Betty had done. Do you remember getting that question?
Not in the way you're...
Okay. There's no, in your review of the record, was there any notification from the family complaining about Miss Betty regarding any improper touching or stroking or anything of that nature? Okay.
No.
And finally, regarding, just briefly on the joint commissions, the accreditation body for hospitals, in your experience as a hospital executive officer, is that a requirement for hospitals to participate in federal funding programs?
The Joint Commission is a volunteer activity. If they choose to go through it and are accredited, then they are enabled to bill for federal funding.
And from your review of the materials you have, either publicly available or otherwise, did it appear that all Children's had participated in that program?
Yes.
I appreciate your time.
Mr. Anderson. Members of the jury.
Okay, here comes jury questions. If there are a lot of questions, the jury gets excused, the witness gets excused.
Have I got them all, or are there any more coming?
Judge says, actually, looking at the number of questions, why don't you all step back? Do not discuss this case amongst yourselves. Do not do any investigation and receive no information. That's a good sign for us. That means we should get to hear what these questions are. Here we go.
Looking at the number of questions, why don't you all step back? Do not discuss this case amongst yourselves. Do not do any investigation and receive no information.
All right, so the next thing.
Okay, the jury is out of our presence. Mr. Anderson, I need you to step out of our presence so we can go over these questions outside your presence. The witness is leaving the room right now. Witness Mr. Anderson is out of our presence. Red number 1. If the hospital had all of the paper, if the hospital had all of the proper protocols in place and and he's struggling to read this. He's pausing. He says, well, you can help me with that red underline. And departmental reviews, would a patient or patient's parents' complaints about a specific employee be documented and reviewed by supervisors, especially if the complainants were multiple? It's a tough question. The judges struggled with some of their handwriting. Or are only performances showed by other staff and peers of an employee documented for review? Judge says, I think I'm going to need some help on deciphering that one. Krill says periodic. Krill says performances observed. I think the underlined words are periodic and observed. Grill says it helps if you have bad handwriting, you can read others. The judge says my handwriting is pretty cruel, but Grill says, do you agree with that's what this is? Judge says, okay, let me see if I can read it in context. If the hospital had all of the proper protocols in place and periodic departmental reviews, would a patient or patient's parent complaints about a specific employee be documented and reviewed by supervisors, especially if the complaints were multiple? Or are only performances observed, but other staff and peers of an employee documented for review? Curl says, is it by and not but? Judge says, I guess, perhaps. No objection, says Mr. Shapiro. Curl says no objection. Mr. Anderson goes, This is question number 1. Did you see a letter from Beata Kowalski about action of some of J. Hatch's employees in the care of Maya Kowalski? Do you know the name of supervisor that the review of Miss Beatty, does she still work at J. Hatch? Do you know the name of supervisor that, I don't know what this is. Is that a word or is that a scratch out? The review of Miss Beatty. I think, says the judge, I think the juror is asking about the name of the supervisor of Miss Beatty. I think. Carell says, it sounds like a judge. Mr. Whitney says, did a review of Miss Beatty. Judge says, is that did? Thank you. No objections, says Mr. Anderson. If you guys can count the objections. Shapiro says no objections. Anderson says, was that 2? Or was that the second of 1? Judge says, well, we're on red number 2 right now, but there's 2 on this. So we're okay with this one? Yes, sir. Moving on to red number 3. First one was scratched out. Number 2, but really it's number 1. Do you believe the 2-day surveillance was done with the right intent, given the statement made between Dr. Dees and Dr. Smith that, quote, a 10-year-old can't keep up the charade 24-7? How many disciplinary meetings were there? What were they about? Are you aware of any improvements All Children's Hospital has made to leadership communication, quality, and or risk management since 2016? Did you say the pictures taken were to look for child abuse? They were taken in January, which is 3 months after Maya was checked into the hospital. Why didn't you review the Joint Commission reports? Mr. Anderson says no objection. Krill says, well, Shapiro says, well, the objection we're going to make then silence. I object to what's involved in number 4. I think it was the third question. Judge says, go ahead. Mr. Anderson says, you mean how it's phrased? They're mumbling to each other right now. I added this objection already. Beth, welcome. Thank you so much. Yellow Courthouse. Appreciate your support. Mr. Anderson says something about patient quality. I don't know that 408 extends to something like this. It's more of a product liability idea, and that goes to their policies and procedures. Judge says, I agree with the defense. What is written as question number 4, which is really the third on red number 3, goes to subsequent remedial measures and will not be asked. Other than that, we're okay? Yes, Your Honor, says Shapiro. Yes, says Anderson. Red number 4. Mr. CEO Anderson, I'm a bit confused as to the reason for the photos you stated. I passed witness testimony. I thought the reason for photos with Maya was she was in her skivvies, was before court, and past testimony said another set was taken upon return from Maya's court appearance in order to document any, quote, new, end quote, body marks while not in the hospital's direct care. In your testimony, you said that Maya disrobed in photos was for diagnostics. Diagnostics was in quotes. The quote, provided documents, in quote, you were provided and reviewed something akin to something photos taken this date of Maya to be used for diagnostics or for comparison. Or do you recall what you read that made you testify the photos were, quote, for diagnostics? That's a tough question. I think the juror tripped over himself and got lost in writing it a little bit. But yes, they're definitely listening and paying very good attention. There's Jules there with her notepad in the courtroom. No objections, says Mr. Anderson. Krill says, we have no reason. She said, oh, I thought you were not able to read what he said, but he actually said something. Krill says, I thought you didn't know what he said. Shapiro says, the only objections to the preamble. If I can just read the first part, causes confusion. Mr. Anderson says, I think the first part puts it into context. The judge says, on this one, I agree with the plaintiffs. I will read it. Anything else? No, Your Honor. That's it. Let's bring in the jury. Let's bring in the witness, Mr. Anderson. Okay, so that was the jurors' questions reviews. Sorry, some of those questions were, you'll hear them when they're read. They're sort of phrased in an interesting way. The jury is retaining past testimony. Yes, and we have one more objection as well. Thank you for helping me out with that. Okay.
All rise. Jurors entering.
And Mr. Witness Anderson, or Witness Mr. Anderson, let me ask the jury my questions. I want to confirm while you're away, you did not discuss this case amongst yourselves, did no investigation and received no information. Is that correct? No media? Correct. No contact? Correct. Okay. And Witness Mr. Anderson was outside the presence when I went over these questions with the attorneys, so this will be the first time he's hearing them. Mr. Anderson, if the hospital had all of the proper protocols in place and periodic department reviews, would a patient or patient's parents' complaints about a specific employee be documented and reviewed by supervisors, especially if the complaints were multiple?
Yes. When the parents make a complaint, it would go through whoever they complained to. If they were complaining to a physician, go through that process with an employee the same. But it would be looked at and followed up through HR and with the employee if there was an official complaint.
Are only performances observed by other staff and peers of an employee documented for review? I think this question follows that last question.
when behavior is looked at as well as complaints or anything that might come to an attention, but a review that is conducted is really the observations of the supervisor, any external comments or from other departments, and then the 360 review, where there is commentary from the peers of the employee.
Did you see a letter from Beata Kowalski about action of some of Johns Hopkins All Children's Hospital's employees in the care of Maya Kowalski?
Do
you want me to read it again?
Of patients other than Maya?
Let me read it again. Did you see a letter from Beata Kowalski about action of some of Johns Hopkins All Children's Hospital employees in the care of Maya Kowalski?
I do not recollect that, no.
Do you know the name of the supervisor that did the review of Miss Beatty, and does she still work at Johns Hopkins All Children's Hospital?
I believe the name of the supervisor who did the review is Chris Drisdell. I'm sorry. Get it out. I have no idea if the individual is still at the hospital or not.
Do you believe the 2-day surveillance was done with the right intent, given the statement made between Doctors Dees and Smith that, quote, a 10-year-old can't keep up the charade 24/7, end quote?
Wow.
I would set aside to comment and answer that I think there was an exploration of a diagnosis that was still being explored, that of is there abuse, so that there was justification for the order.
How many disciplinary meetings were there, and what were they about?
I don't understand that.
I'm assuming the context is Kathy Beatty. Yes.
I think from the documentation that I see now is I think there are 2. That's what's referenced.
Did you say the pictures taken were to look for child abuse?
I think that was part of it. I think there is in Johns Hopkins, if there was an examination to look for abuse, then that was part of the reason for the photographs. But I also think that it's my understanding that if an individual is to make a court appearance or to leave the hospital, there are photographs taken at that time as well.
The photos were taken in January, which is 3 months after Maya was checked into the hospital. You're aware of that?
Not the specific date.
Okay. Why did you not review the Joint Commission reports?
The Joint Commission entirety of the report or reports is what I was making my comments about, was that the hospital had been surveyed and had been accredited, and I wasn't referencing having seen the report. I was acknowledging that they had gone through the process of evaluation by the surveyors and that they had received accreditation and for their performance and review.
He looks to defense on that one.
This is a little bit lengthier question. I am a bit confused as to the reason for the photos you stated. By past witness testimony, I thought the reason for photos when Maya was in her skivvies was before court, and past testimony said another set was taken upon return from Maya's court appearance in order to document any, quote, new, end quote, body marks while not in the hospital's direct care. In your testimony, you said the Maya disrobe for photos was for, quote, diagnostics, end quote. The, quote, provided documents, end quote, you were provided and reviewed something photos taken this date of Maya to be used for diagnosis or for comparison? Or do you recall what you read that made you testify the photos were, quote, for diagnostics, end quote?
What I was referencing that I had seen in the documentation was the request for photos by Dr. Smith and Dees. And that was to assist in the pursuit of the diagnosis of whether or not that was contributed to a diagnosis of child abuse. That was the referencing that I was making.
Mr. Shapiro, do you have further questions?
Not at this time.
Mr. Anderson. Attorney Mr. Anderson.
So you agree that senior hospital management were kept informed regarding Maya's care and treatment between December 2016 and January 2017, right?
Could you repeat that again, please?
You agree that senior hospital management then knew about Maya Kowalski's care during her stay there?
I don't know specifically which senior leaders knew of her stay there. What I was saying in my testimony was that it's very common that there are multiple shelter orders in place, and that senior leadership would not necessarily intervene on those cases as long as the care of the patient was proceeding and was not rising to a level of crisis. Patient was stable. That was my reference in terms of indicating why or why not certain individuals might know of Maya's condition in the hospital.
So is your answer yes, you just can't tell us which senior official?
Well, Mr. Anderson, I can't tell you which senior officials knew.
I don't know. We're speaking the same language. I'm saying, are we in agreement that in your opinion, senior management knew, you just can't tell us which one of the senior management?
I don't think defense talked to him at all at lunch. I think they're professionals.
I believe that there were senior managers who did know, but I don't know who they were.
Thank you. You've never seen any indication of any review of Ms. Beatty's conduct outside of the corrective action I showed you, right?
Not from Ms. Beatty.
Right. So all of the actions I was talking to you about, in other words, the photography, the sitting on the lap, all of those, you never saw anywhere in the records any corrective action as to Ms. Beatty, did you?
No, because I saw no official complaint lodged about any of those activities.
That's not my question. My question was, did you see in your review any indication that anyone at Johns Hopkins took any action regarding that?
No, I did not.
And as to the photos themselves, 48 hours as well. If they were going to be for diagnostic purposes, you would expect to see some medical analysis of them, would you not?
There should have been a review, yes.
And they should have appeared in the medical records, one would think.
That would be the logical place to see them.
Thank you.
But they didn't.
Mr. Shapiro.
To be clear, Mr. Anderson, having reviewed the sworn testimony of Miss Beatty that we did provide you, she denies the allegations against her, does she not?
Yes, she does.
And in terms of your review of what was provided to certain levels of leadership, is what I understand your testimony to be that there were members of risk management that were consulted about certain legal obligations?
That's correct.
Do you know whether those people in risk management were at senior leadership or executive levels versus lower level risk managers?
I do not.
Action leading.
Do you know, as you sit here today, what the level of executive leadership was that were consulted on those questions?
No, sir, not all of it, no.
Oh, thank you.
Anything further, Mr. Anderson?
Can we put up trial exhibit 2277-628A? 2277-628.
Is it in evidence?
Yes.
It's in evidence.
You may.
While we're waiting, do you know who Jackie Crane is?
I've seen the name on the organizational chart of Johns Hopkins and knew she was the senior counsel.
Does this exhibit show a copy to Jackie Crane?
Yes, it does.
And at the bottom there, not the next to the bottom after a lot of the whiteout, does it advise a doctor to get pictures of the scratches?
Yes, it does.
Right. And when you explained before on that flow chart, that organizational chart, Jackie Crane was directly linked to the president, correct?
She has a reporting relationship to the president.
Nothing further.
No further redirect. Thank you.
And members of the jury, do any of you have, it looks like we have further questions. Let's see if we can do that just up here without having to send everybody to.
Yeah, that means we don't get to hear these. So the sound gets turned off on Zoom as well. All right. I apologize if I've put too much emphasis on the time. I don't know how it's going to end. I don't know what the judge will do when time runs out. But the fact is, time is running, and they're approaching the hour mark for today alone. They only have 6 hours and 20 minutes left. We have a week left of trial. They've been using more than an hour every day. To me, the math doesn't add up. To me, it looks like they're going to have to just sit there silent for large portions of days to be able to get to the end, because key witnesses will be happening at the end. But we'll keep tracking it, and we'll see what happens. The judge might have a remedy that now this will become a big nothing burger. So the math isn't mathing, says Christina. We need time for Miss Beatty and Sally Smith. Yes, I think they will. I think they'll have time. With Miss Beatty coming tomorrow, even if they used an hour on her, then they've got Friday. If they use another hour and a half, they've still got 2 hours on Monday. That's when that is, but then they'd run out of time later on. So I think they have enough time for those two as long as we don't have depositions that have a lot of designated time from the plaintiffs in the meantime. Let's see, Mama Bet says if he doesn't connect this fiasco to management, they lose. And he did just draw the connection. He literally just had that, the Crane, I forget her first name. Her last name was Crane, who reports directly to the top dog. She's like the number 2 on the chain. She has a reporting relationship directly to the top. And she is copied on this email about the pictures. That, I think, made the connection as much as they need to. BD is Monday to the best of our knowledge. Obviously, all these things can change, even at the last minute. It's our understanding that the time does not include closing arguments. So those are separate. KCAT says, I would bet questions from Beatty and Smith from the jury will last hours. Live stream just stopped from the court. That's our Colorado court just broke for lunch. That's 2:06. Okay, so we need an hour probably. I'd like to hear the reason.
This is actually my question, not the jury's question, but in your testimony a few moments ago, did you say exploration of a diagnosis or expiration of a diagnosis?
Exploration.
Exploration, okay. At this point, I'm not going to ask that question. Next question. Do you think Johns Hopkins All Children's Hospital needs to change their policies for patient and safety care?
From the records that I saw, from the chart that I saw and the way that they have organized the hospital, their framework for managing safety issues, patient care issues is there. From what I saw in the record, there is internal communication going on daily on a real-time basis relative to patients' care. So I believe that Johns Hopkins does have appropriate models for the safety of their patients.
Mr. Shapiro, anything follow up?
No, thank you.
Mr. Anderson, anything further?
Have you seen the testimony of Drs. Perno and Napolitano about the lack of such day-to-day review?
Objection, mischaracterization.
Overruled. You can answer.
There are structures that exist that departmentally safety items are involved. What they were referencing was their particular involvement in some of those activities. But there are, through the different medical staff committees and through the department structures, there are avenues for quality care to be done and to be monitored.
I just asked you whether or not you were aware that both of them testified about that.
Same objection, mischaracterization.
They both testified about that to my knowledge.
Nothing further.
Nothing further.
Okay. Mr. Witness Anderson, you're free to go today, although you're still under subpoena and we may need to call you back. Okay?
Okay.
Thank you. Defense, who's next?
Defense calls William Cecil, Doctor of Physical Therapy.
So Dr. William Cecil, who's a doctor of physical therapy, is going to be up next. Mr. Mark Anderson is released. The reason the judge did not release him from his subpoena, oh look, he's chilling out there in court. He's chilling. He's an expert witness. I guess he can do that. The reason he didn't release him is we have that issue of documents that the plaintiff may wish to cross him on at some point as they get those documents today and review them tomorrow.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. I have right to swear.
May I please report?
Yes, sir.
Good afternoon, sir. How are you doing?
I'm good. How are you?
A little tired, but other than that, I'm okay. Thanks for asking. Could you please introduce yourself to the jury, please?
Yeah, my name is Dr. William Cecil. I'm a doctorate of physical therapy.
Can you give the jury the benefit of your education and training, the type of certificates and colleges and things of that nature that allowed you to become a doctor of physical therapy?
Sure. I did my undergraduate degree at the University of Florida, graduated in 2007, and then I then went to physical therapy school at Nova Southeastern University, where I studied for 4 years, including clinical internships in various settings, and graduated with my doctorate of physical therapy, and then sat for the Florida licensure exam.
Could you please explain for the jury what it is that a pediatric doctor of physical therapy such as yourself does on a day-in, day-out basis, recognizing that many of our jurors probably aren't doctors of physical therapy?
Sure. So I work in an inpatient setting, which means I'm in the hospital working with children with various illnesses. On a daily basis, I can help a child with cancer, and then a kiddo after a heart surgery or after a trauma, car accident. And my goal with each one of these patients is to help them recover whatever function they've lost, help them to identify what those weaknesses are, those abilities that they've lost based on their situation, and help recover that back to their normal baseline function.
Mr. Cecil, why is it that you chose to go into pediatric physical therapy as your calling?
I've always loved working with kids and families. Before I even thought of doing physical therapy, I worked for the YMCA, doing before and after care programs, working summer camps, worked for that organization for several years. I just love that dynamic of helping kids and then also working with kids and families to make that child's life better. So I took that experience and kind of parlayed that into my career, going into physical therapy, where you're not only helping kids, you're not helping kids academically, but you're helping them physically recover from a tough situation, whatever that may be.
Could you please give a brief explanation of your past employment history, places you've worked, things of that nature?
Sure. So I worked for the YMCA, as I said. After physical therapy school, I worked at a small outpatient clinic with adults for about 6 months, and then I was hired at Johns Hopkins All Children's. I had a clinical internship there prior, and I've been employed there ever since.
And approximately when did you start at All Children's Hospital?
I started at Johns Hopkins in 2015, and I've had continuous employment with them since.
Okay. And what is your current position?
I'm an acute care physical therapist.
And what was your position or title at the time that you came to care for Maya Kowalski back in October through December of 2016 and into January of 2017?
It's the same as it is now, acute care physical therapy, doing the same job, same general populations.
Could you give the jury a brief description of your work experience within your career with complex regional pain syndrome and other amplified pain disorders?
Sure. Over my career, most of that at Johns Hopkins, I've had significant experience with CRPS patients in chronic pain. I'm one of the primary therapists in our CRPS program, who's worked with dozens of CRPS and chronic pain patients over that period. doing various, during different programs. Even when I worked outpatient for a short period of time, I saw patients in that setting also. So since I started Johns Hopkins, I've had the privilege to work with many patients with CRPS.
Now, my understanding is Johns Hopkins All Children's Hospital currently has a CRPS chronic pain clinic. Is that correct?
Yes, that's correct.
And about when did that program launch? Approximately.
I am not sure. I'm not sure exactly on when it started, but on the inpatient side, so we use our outpatient clinic and our inpatient facility as part of that program. I work on the inpatient side, so I'm not sure on the outpatient side when that exactly started.
And at the time you cared for Maya Kowalski, did Johns Hopkins All Children's Hospital have a CRPS clinic at that time?
No, sir.
Okay. Do you notice any difference with the way that you treated Maya Kowalski back in 2016 with the modalities that you currently employ with the CRPS clinic at Johns Hopkins?
Sure. So reviewing the notes from Maya, everything I did with her back in 2016 are the same types of treatments that we use now. Any patient who has CRPS, the goal of the physical therapist is to assess the deficits, find what's hard for them to do, and then come up with a treatment plan to improve those deficits. And the strategies we used then are the same exact strategies we use now. Nothing has changed.
Now, the jury's heard some testimony that complex regional pain syndrome is a regional syndrome. What does that mean to you as a doctor of physical therapy?
Objection, beyond scope, improper foundation, predicate as to medical diagnosis.
Anderson will be crossing.
Overruled. You can answer.
So regional for me would indicate kind of one area of the body, one location, whether it's a leg or an arm, not a global full body syndrome or experience.
Now, I'd like to take you back in time to October, November, December of 2016 and into January of 2017 and your care with Maya Kowalski. Do you have any recollection as you sit here today of your treatment of Maya Kowalski?
Yes, I remember Maya well. She was easy to get along with. She was very pleasant whenever I worked with her. Some things that come to mind is like there's very distinct inconsistencies with how she participated and presented during her therapy sessions. Oftentimes she would refuse to do certain things that she did days before or in previous sessions, and we had a hard time. I had a hard time educating her. She was very resistant to any education I tried to provide to her on what we're doing, why we're doing it, trying to explain the importance of physical therapy.
Now, the jury's going to have an opportunity to look at some of your notes today, and all of your notes will be in evidence as well. I see here that you personally provided 21 sessions of physical therapy over approximately 20 hours. Does that comport with your review of the records?
That sounds correct.
Okay. And I believe there was somebody else in the PT department that also handled some of Maya Kowalski's consults as well?
Yes, sir.
Do you recall who that individual was?
Her name's Elizabeth Harper.
But fair to say you handled the majority of the PT sessions during Maya Kowalski's hospitalization at All Children's?
I believe that's correct.
Why don't you tell the jury a little bit about your relationship that you had with Maya Kowalski over the course of those 21 sessions?
Sure. Like I said, it was very, very pleasant. We would, I would enter her room and talk to her, kind of see how she was doing that day. We would talk about what the plan is for that day. I would give some goals, things that I would like to see her do. Oftentimes she would kind of push back on that, and there's things that she refused to do frequently. But we worked together as a team trying to achieve some goals that I had said and we had discussed together to improve her function. Never pushing her to do things that she was ever uncomfortable with or things that she never agreed to. But coming up with that plan together, which is really an important role for the physical therapist, right? We need our patients to buy in and build rapport with us so that we can make improvement over whether it's a short period of time or a long period of time.
Now, when you started out with Maya Kowalski in October of 2016, did you formulate a kind of a game plan moving forward for the course of your physical therapy treatments with her?
Yeah, so initially, I wasn't the one who performed her initial evaluation, but reviewed those notes, kind of saw what she was able to do at that point. And in your mind as a physical therapist, you're always assessing. You're always trying to find those weaknesses, find where we're improving and where we can make steps forward, so that with an eventual goal of being able to get back to normal life, whether that's walking or running or participating in activities. So you come up with a game plan, maybe initially, but every single time you see that patient, you're reassessing, you're re-examining that patient and seeing where they are that day compared to the previous days.
And so, if I'm understanding your testimony correctly, you're literally assessing on a session-by-session basis and tailoring your treatments based on what you're observing in real time?
Yes, sir, that's correct.
It's not a cookie-cutter approach?
Objection, leading.
Sustained.
How would you characterize Maya Kowalski's trajectory and improvement over the course of the 21 sessions that you provided?
Sure. So if you look at her initial evaluation and the documentation and then the final PT note, there are some areas of significant improvement. There are really three areas that we worked on every single time. One was her sitting balance. When she was first evaluated, the documentation shows that she required min to mod assist, which means she required 50% effort from the therapist, and she provided 50% of the effort just to maintain sitting. Not doing any activities, not reaching for the remote or anything like that. 50% help just to sit for 2 minutes. By the end, when she left the hospital, she was able to sit in her wheelchair completely independently, no back support, no arm support, and participate in activities, whether it was a game, whether it was piano, whether it was grabbing things from the floor. She was able to do all those things by herself. So that was one area that was improved. Another area that improved was her posture, especially her sitting posture. On her evaluation, she was in this slumped posture, unable to hold herself up, and complaining of back pain whenever she straightened up. Throughout the admission, she consistently had an upright posture, able to hold herself up with a straight spine, and no consistent complaints of back pain during that time. The third area was her activity tolerance. So again, on that evaluation, all she was able to do was sit on the side of the bed with 50% support for 2 minutes. That's all she was able to do. Throughout the entire admission, including at the very end, she was participating in physical therapy activities for 45, 60, sometimes 75 minutes with minimal complaints during our session. So all three of those were significantly improved from what her evaluation on that very first day we saw her was.
Now, we're going to talk about this when we talk about some of your notes with the jury, as well as watch a video, but one of the things I think I heard you talk about was this concept of dynamic sitting balance that you saw improve over time. Can you tell the jury what the concept of dynamic sitting balance is to you as a PT?
Sure. So when talking about sitting balance from a physical therapy perspective, there are two things we need to consider. We break it into two parts: static sitting balance and dynamic sitting balance. So static sitting balance would be just sitting, not doing anything. How well can you maintain your balance sitting with no supports, not doing anything? Dynamic would be adding in any external stimulus. So playing a game, reaching, swaying our body back and forth, reaching to the ground, even providing external stimulus, so like throwing a ball back and forth. That impact of the ball coming to you requires you to use your core to maintain your sitting balance, or else you're just going to fall over. So that's the difference between, we have this static balance and we have this dynamic balance.
Now, early in your testimony, you mentioned that there were sometimes some inconsistencies with some of the things that Maya would report she could or couldn't do. What did you mean by that?
Sure. Oftentimes I'd ask her to do something such as help me sit her up in bed, or let's sit and put our feet on the ground and reach to play a game. She would often say, I can't do that, or push back and resist, or say it'll be too painful. But then moments later, whether we're in conversation or we're playing a game or she's being distracted some other way, you would notice her feet on the ground. She'd be sitting up straight by herself, not leaning over a wheelchair, having zero difficulty doing any of that sitting balance task.
I'd like to draw your attention what's been entered into evidence as
doing any of that sitting balance task.
I'd like to draw your attention what's been entered into evidence as Joint Exhibit 1001, 1905 through 1906. And while we're waiting to get that up for you and for the jury, I'll represent to you that this is a physical therapy progress note from November 30, 2016. Fair to say you had an opportunity to review this document fairly recently?
Yes, sir.
Do you see here on the first page, the 1905 page, where we'll highlight there just for the jury that it says November 30, 2016? Oh, I guess what I'd like to do is highlight the section here on 1906 under general objective. Do you see where we're going to highlight here for you where it says patient? Patient refuses to participate in any therapeutic activities in the rehab gym this date. Do you see that?
Yes, sir.
Okay. Take a moment to read the highlighted passage for me. I'm going to have some follow-up questions for you, okay? You can continue the highlighting for another couple sentences, please.
I would love to welcome you by name.
Unable to repeat.
I'm not sure if this is Ajsa Karasik. I don't know how to say your name. Give me a spelling pronunciation. I'd welcome you by name.
Mr. Cecil, I wanted to ask you about this. Is this an example of the type of sitting balance inconsistency you were talking about earlier in your testimony?
Yes, sir.
Okay.
Objection, meeting.
Can you please describe for the jury what it is that we've got highlighted here and how it ties into your treatment of Mike Kowalski as well as your observation of inconsistencies?
Sure. So she refused to participate in things at the gym. That was our, the gym, the physical therapy gym, the inpatient rehab gym. It's a place we take most of our patients who are able to leave their room, that we have functional goals for. So in the gym we have items like practice stairs, we have play mats, we have parallel bars that help retrain people to walk, we have other specialty equipment. So that's why we typically go there, because it has all of our things that we like to use to help improve our function. This day she happened to refuse. We had a conversation that the benefits of going to the gym, but she refused. So instead, we went down to the first floor where there's a piano. And while down there, she was able to play the piano without difficulty. So that involved sitting up straight, leaning forward, reaching forward, playing the piano without any loss of balance. No difficulty, no signs of distress, facial grimace, or anything like that. During that time, as it says here, I noticed that it says bilateral lower extremity, so both of her legs were in near full extension with controlled movement. What that means, that's kind of fancy medical terms for, she was kicking her legs all the way straight, or near all the way straight, which is something that she had said consistently she couldn't do. So this was something to take note of, because it's something that we rarely, if ever, saw happen. So she was kicking her legs nearly all the way straight in a controlled motion. It wasn't just kind of flopping all over the place, which would indicate, poor muscle tone or poor strength. But it was a controlled motion, kind of all the way into extension or near extension, and then back down. The next sentence, as it says, when I brought attention to this, because I wanted her to know, hey, look, you're doing this. Your legs are moving. Like, we can parlay this. We can use this to progress into more strengthening for your legs, into some more movement that's going to make you more independent at home. When I did that, she immediately was unable to repeat. She stopped moving her legs altogether, and we didn't see that again on this day.
And why is this significant to you as a doctor of physical therapy, what you're describing here for the jury?
Yeah, this is significant because she consistently, this was November 30th. This is already a month or more into seeing her. She had consistently every single day said she can't do things like this. And during our sessions, we try to get her to participate in activities that are going to strengthen her legs in order to become more functional, which was refused most of the time. So being able to see her do this with no visible signs of pain was significant.
I'd like to now pull up a video for you. It's been marked in evidence as 3089, please. And why don't we watch that together, and I'll have a few follow-up questions for you, okay? And I'll represent to you this is a video from the lobby at Johns Hopkins Children's Hospital. So, Mr. Cecil, I'd like to ask you, just as a doctor of physical therapy watching that video, what stands out to you as significant that might help this jury?
Yeah, there were several things. So the first thing that you look at, if you look at her posture, she's sitting up straight. She's scooted forward in her wheelchair off of the back support. So she's not using the back support to help her stay upright. Also, her arms are not on the armrests. She's forward on the keys. So she's using her core and back muscles to maintain that posture. That's the number one first thing. Secondly, at the very end, you kind of see her move to the side. She's moving the wheelchair. No one's pushing it. She's moving it to the side, kind of using her hands. And if you look closely, she actually moved her legs to help move her wheelchair to the right. Her toes and the balls of her feet, kind of the knuckles of her feet, are on the ground the entire time. And she's smiling at a point. She has a smile. So it's significant that her feet are on the ground, her legs moved, she's smiling, which is things that she verbally said that she was unable to do. And when asked to do things similar to this, completely refused and said it was too painful to perform those activities.
Now, the jury's heard a little bit throughout this case about the concept of distractibility. Do you know what that is?
Yes, sir.
Can you please explain what that is for the jury, please?
Yeah, so distractibility is a technique that all therapists use, especially with patients who are in pain. We try to make conversation or use games or crafts or other things to distract the patient from their pain in order for them to participate better in our therapy session. We're not ignoring their pain. We are using external items or games or things to shift their focus to something else.
Did you ever utilize any distractibility technique with Maya Kowalski? And if so, can you please tell the jury a little bit about your observations in that regard?
Yeah, every single session. Distraction was basically the only non-pharmacological, so no medication pain technique that we could use that was effective in helping her to participate better in therapy. So frequently we would engage in conversation, talking about music or what do you like to do or things like this. Or throughout my documentation, you see we're playing games, whether it's laying flat on her stomach on a play mat with her propped on her elbows playing a game, or sitting in a chair with a game in front of her, working on her posture. providing that external influence or focus to take her focus off of her pain and go towards participating more and more.
I'd like to draw your attention now to what's been entered into evidence as Joint Exhibit 1001-1900. And I'll represent to you that this is a physical therapy note from All Children's Hospital on December 3rd of 2020. Have you had an opportunity to review this note before today?
Yes, sir.
I'd like to draw your attention to the section here that says patients aren't visiting at gym at time of therapy session and remain present throughout session. Do you see that section of the note?
Yes, sir.
Do you recall anything about interacting with members of Maya Kowalski's family that came to visit at Johns Hopkins Children's Hospital?
The only thing I remember is the aunt was present during this session, and then I think there was once or twice where our session was finishing, and I believe her father was in the room kind of waiting for her to return back. So I would drop her off back to the room, and her father was in the room at that time. That's the only time I remember seeing any family.
And I'll draw your attention to some highlighted portions here under assessment and goals. And while that's getting pulled up, can you explain to the jury what stands out in your mind during this visit from December 3rd of 2020?
Sure. May I take a moment to reread it?
Yeah, sure. They're going to pull it up for you. There you go.
Let you guys see that there briefly. Y'all caught up? You read it? This looks like a pretty good report.
Yeah,
pretty thorough.
So the big thing that stands out here is that with her aunt present during this session, her presentation was very different than previous sessions. In previous sessions, using our distraction techniques and kind of focusing on function, she was able to participate fully. She didn't have any issues with her balance or needing to lean side to side. Here, with family present, you can see she was leaning. So if we put her next to the parallel bars, which are these straight bars that help us teach people how to walk, she was leaning over across them the entire time. Stating that she couldn't sit upright, she couldn't do certain things. But once we pulled out a game, so she was, I don't know if it was a card game or something, but it says she was doing in-hand manipulation, playing a game. So she had pieces inside her hand, playing a game. She was able to sit upright. She was able to participate without leaning on those bars.
Cleo, part of this question goes to the Chapter 39
after
stuff.
That game was
court order.
over. She again started leaning on the bars again, with no change of status, with no nothing in the session changed to require an increased level of support.
At any point, did you ever tell Maya that her pain was not real?
No, sir.
Would you ever do that with a pediatric patient?
I wouldn't say that with any patient. Whenever a patient tells me they have pain, I take that at face value, and we grade our exercises. We either grade up or grade down our exercises based on patient report and what they're able to tolerate.
Since we have limited time here, I'd like to get an idea of why it was that when Maya originally started out with physical therapy, she was doing sessions 6 times per week, and then as the hospitalization progressed, my understanding is she was cut back to 3 physical therapy sessions per week. Can you provide insight to the jury as to why that was?
Yeah, so we started 6 times a week because she had these large functional impairments when she first came, right? She wasn't walking, she wasn't propelling her wheelchair, she wasn't standing, all these things. And while that didn't change, the quality of her participation in therapy did change. She started participating less and less. If you look at the therapy notes from the beginning, she was willing to attempt standing. She agreed to try, and I believe she tried her best. And we would encourage her to keep working at it. That's how we're going to improve. But there came a time, I think, only a few sessions in where she completely refused standing. So there came a point later on, I think it was in December, that the amount of improvement we were going to make with how much she was participating, we were kind of at a plateau point. We were doing really well on our sitting balance. She was participating in 60 minutes to 75 minutes of therapy per session. But she wasn't willing and wasn't able to participate in standing, attempt walking, anything like that. So we cut her back to 3 days a week with the knowledge of if she showed more participation, if she was able to move her legs, if she was willing to do those things to attempt standing, we could immediately increase that frequency back up to 6 or 7 or whatever was appropriate.
Over the course of observing Maya Kowalski over the sessions that you did you ever notice Maya Kowalski's feet in the anatomically correct position or in an inverted dystonic presentation?
To my recollection, I never saw them in an inverted dystonic position. They were always in a kind of relaxed down, pointed down position.
Were there ever any times that Maya Kowalski would describe her history of using pain medications with you during a physical therapy session?
There were frequent times when I would try to educate her on physical therapy, like what we do, why we do it, why physical therapy is a part of the treatment plan for CRPS. She was always very resistant, and she would frequently say, this treatment isn't going to work. Physical therapy isn't the treatment I need. I only need ketamine. That's the only thing that's going to work for me. And that she would say that was said multiple times.
And how would you respond when those types of topics would come up, when Maya would insist that ketamine was the only way to get better?
I would just continue trying to educate her on the physical therapy role on CRPS and how what we do is going to help her get better with her participation.
Did you ever see Maya Kowalski's legs in a position known as crisscross applesauce, also used to be known as Indian style?
Yes, sir.
Why is that significant to you as somebody in your field?
I would see them in that position frequently when I would pick her up from her room. Sometimes she'd be in her bed sitting in that position. The question that always popped in my head is, how did you get in that position? Because she wasn't moving her legs during her time with me, very minimal movement, except for a couple of times, as we saw in the notes. So I would think, I don't think I ever brought it up to her because she'd be very defensive, but I always wondered how you got in that position. Did you use your arms to get your legs in that position? Did you move your legs to get in that position? Then also, how are you tolerating that position? Because most of the time she would complain about this severe allodynia, which is sensitivity, severe pain to touch. She'd be complaining of severe pain to any touch to her legs. And I would wonder, so I would think in my head, like, this is one of those inconsistencies, right? She was able to tolerate this crisscross position with her legs on top of each other. But any other touch from a provider, including me, would cause severe pain complaints.
Do you remember any types of clothing or jewelry that Maya Kowalski used to wear? And if so, how is that significant to your observations?
She wore a variety of different clothing. I remember wearing shorts, pants, leggings, various things during our session, and the same kind of thing. Like, and if I tried to help her do a leg kick together, assisted, she wouldn't tolerate it. But this material on her legs didn't seem to cause a problem. So just another inconsistency.
Now, despite these inconsistencies, though, you didn't give up on Maya, did you?
Never. I never give up on any of my patients.
Why don't you tell the jury a little bit about the continual efforts you made, including all the way through towards the end of physical therapy with Maya Kowalski?
Sure. My goal the first time I saw her was to help her get better. I wanted her to leave our hospital walking. I wanted her to leave there walking, be able to go back to school, walk around school, do the activities she wanted to do. That's what as physical therapists, that's what we all enjoy, right? We got into the profession because we like helping kids get better. We like seeing them go from an injury or an illness back to a sports field or back to participating in school or whatever their passion is. So that was my goal for her all the way through. So using the therapy techniques, the exercises, the activities to try to help her get stronger and more active. That was my goal all the way through.
Now, at the very end of your 21 sessions with Maya Kowalski, in fact, I think it's one of the last, if not the last line in your charting, you noted that Maya, quote, displays functional strength to complete tasks, but when asked to perform specific activities, she actively presents with impaired function. That's a little bit of a mouthful, so why don't you break that down for the jury and describe what you're explaining there as you kind of finished up and wrapped up with your sessions with Maya Kowalski.
Yeah. Do you happen to have it on the monitor so I can reference it? Or?
I actually don't, but...
Can you say it one more time for me?
Yeah, she displays functional strength to complete tasks, but when asked...
Why don't we just hand it to him? Let's not read things and let's not read it twice.
Can I approach?
Sure.
I apologize, Joe.
Mr. Hughes was not allowed to read the report to him.
All right, so...
It's not my charting here, so I'll withdraw the question. Hold on a second. Y'all come up, please.
Ooh, y'all come up, please. So Mr. Hughes handed all of his notes to the witness, which the witness looked at. And now I wonder if Mr. Anderson wants a copy of Mr. Hughes' notes. I don't know. Rules be rules, right? Rules be rules. Judge is hammering out the details here. This witness seems to be very consistent and very believable in his style about how he interacted with Maya and what he observed. The only part that caught me was he said that Maya was very defensive about something. And it has to do with her being sitting, cross-legged, and so he said, "I'd come in, I'd wonder, how'd you get positioned like that? How'd you get your legs in that position? You lift yourself up with your hands, and you move your legs to do it. How'd that happen?" And he said, "So I'd come in, I wonder that, but I never told her that because she's very defensive. I just wondered it in my head." How does she get very defensive about something you've never brought up to her? Broughton. I'm creating words here as well.
Mr. Hughes, did you have any other further questions? Let me figure out the timing here.
Ooh, you're done.
Do you all want to break? I saw several people stand up, so... Or do you want to keep going? Keep going. There we go, Mr. Anderson. You may go.
Here we go.
Have you ever heard of the term confirmation bias?
Yes, sir.
What is confirmation bias?
My understanding, confirmation bias is using the information in front of you to come to a conclusion that you desire or you perceive to be the truth.
It's where you're told something also by somebody else about a person, a thing, an object. And it's the lens through which you then view that person, thing, or object. Would you agree with me then?
That could be a definition.
And so when Maya came to you, a couple things were true, weren't they? First, she was only a few weeks away from her ketamine infusions, right?
I have no information on that.
Okay. And the second thing was that let me go back. On confirmation bias, were you told that Maya Kowalski was a victim of either conversion or some other psychosomatic problem?
To my recollection, when I first read through her chart, the diagnosis was CRPS, and I didn't have any other information other than that at the time.
Are you sure that your impressions weren't conversion disorder, deconditioning, and that through reading through her file there, you saw conversion disorder? I mean, not that you saw it physically, but you saw it in her file?
I don't recall seeing that in her file, but deconditioning can also be associated with CRPS.
All right. So at the start, she was just a few weeks away from ketamine treatment. You don't know about that. But she was also willing to do a lot of these activities, right?
At the beginning, she was willing to, agreeable to participate and attempt many things.
Right. But as time went on, she began to complain more and more that it hurt. Did she not?
No, sir.
Do your records not show that she's saying things like, I'm in too much pain today?
Her complaints were never more. They were always consistent all the way through.
Okay. Well, with all the stuff you've got as to her doing or not doing, you've got, of course, photos of this, right?
I have photos of
Maya Kowalski, like, doing all of these things, like being able to do it. I saw the video of her playing the piano, but do you have any photos of her being able to do things that she says she can't do?
No, sir, I don't have photos.
Do you have any videos of her doing things that she says she can't do?
I have my medical records that indicate things that I visualized and saw her do.
Okay. Well, we do. And before we get into that, did you get the same memo the last witness did?
I don't believe so.
Did you get an outline from the defense lawyers about what was going to be asked of you?
From the defense, yes.
Mm-hmm. When did you get that?
Yesterday.
And in there they told you about some things to look for, right?
I don't know what you mean.
Well, they told you, I'm going to ask you about this, or you're going to be asked about that. True?
Yes, that's true.
And in there, or, I don't know, maybe previously, they told you some things you could look through in your records and find, right?
No, sir. They gave me my records and asked me to look through them and be familiar with the things we did during that period.
Knowing the things they were going to ask you about, right?
I think it's prudent to have the information of what I'm going to be asked for.
Right.
Correct.
Well, this was towards a point, and you had been told from the start that you needed to look to see if there were signs of conversion disorder.
I was never asked to do that.
Okay, well, can we put up 1002-0188? And at the bottom there, above chronic pain, we highlight that. Let's see. Now you got to go. Yeah, there you go. Do you see that?
I do.
How'd that conversion disorder get in there if you didn't know anything about it?
There must have been a change in the medical record from the physicians to indicate that they were leaning towards that diagnosis. So that goes into my documentation as a physical therapist.
Well, it's your physical therapy report, is it not?
Yes.
Are you saying somebody broke into your physical therapy report and put conversion disorder in there?
No, I'm saying at some point that I don't recall, in the medical record, her diagnosis must have changed from the physicians to include that, and that way it goes in my order because I work based off a physician order.
All right. Well, Maya's big complaints were in her legs, correct?
She complained about the function of her function of her legs, but it was pain. She complained of pain globally.
All right. But the big thing was you never got her out of the wheelchair, right?
We get out of the wheelchair quite a bit.
Not without considerable help.
With assistance.
Right. And we've got actually, I think, a video to demonstrate that. The 2703D. See, and I want you to then tell the jury whether this is just some assistance. Is that you?
Yes, sir.
Oh, really? If she has your medicine, it should be helping a little bit. I want to try to use the walkers at the stand.
Is that you?
Like you did with that.
Yes, sir, that's me.
Don't tell her that she got to see it. So I'm going to help you, but I want you to try to get your feet flat on the ground. And I'll hold you up to your feet flat. Put your feet down. Turn longer. Better than yesterday. I thought that was awesome. Better than yesterday. I wish we had a feet. That was awesome.
What were you commenting there about her feet?
I did not hear, sir.
Okay. So that was you there, and this was Maya getting up on her feet, right?
Yes, sir.
And would you call that a little bit of help or a lot of help?
She requires a significant amount of help in order to transfer from bed to chair.
Someone's backing
from
up.
any surfaces.
Do you know Rachel DeYoung at Agility Fitness?
No, sir.
Okay, hold on one second, Mr. Anderson. Do you need help there?
It's new. You just
A juror's phone or something. His alarm is going off.
All right, do we have it off now?
I try to keep it in here. It's off.
There we go.
Sorry.
Okay.
Totally no problem. It happened to me the whole time. Okay, where were we? So Maya complains about her legs, and you were never able to get her to take any steps without considerable help. True?
Yes, sir, that's true.
And in fact, you had and documented confirmation of one of the reasons why, didn't you?
I need you to elaborate.
Sure. Well, Maya would exhibit from time to time spasms in her thighs, would she not?
I don't recall seeing spasms in her thighs. I don't think that's in my documentation anywhere.
Okay, can we pull up 1001-1911? Let's look at about the, I guess...
Just another PT report.
4 lines down in the center, highlight please.
Quad spasms
this would seem
noted.
to indicate that she had quad spasms noted throughout the session, would it not?
This indicates that she only had quad spasms when I passively moved her legs, which means she wasn't helping. I lifted them up to work on that range of motion and put them back down.
Well, you just said you didn't document spasms. Will you agree with me now that you documented what are quads? Quads are in your legs, right?
Quads are the muscles in the top of your leg. Yes,
right.
sir.
Hold on a second. Do you want to just put it in the back room? I mean, it's not the 220 national alert. You can continue, Mr. Anderson.
So quad spasms are not something that someone, especially a 10-year-old girl, can create on their own. True?
I would say that's true.
You had objective signs there that in the biggest muscles in her legs, when you move them in certain manners, she had spasms, right?
In this instance, yes, that's true.
And throughout all of your therapy, this was the big thing with her. She did not think she could get up on her legs without, well, because of pain and or loss of, I guess, motive, power, or strength, right?
So spasms can be indicative of many things. Spasms can be a sign of weakness, which we know she had.
Well, I just ask you, sir, whether quad spasms are an involuntary action, right?
Yes.
Okay. And she complained of difficulty moving when she activated her quadratus muscles, right?
This is a passive movement, so she wasn't activating any of these muscles.
I understand that at this time, but that was her complaint, wasn't it? That when she was using these larger muscles in her legs, it was painful to her.
Yes, sir.
And here you take down that she has quad spasms in those muscles, right?
On this occasion, that's true, yes.
Why is it that, do you know who Rachel DeYoung is at Agility Fitness?
No,
okay,
sir.
Do you know Marissa Higgins over at TGH?
No, sir.
Well, Rachel DeYoung at Agility saw her right after you and had a different view of this. Would you agree with me that towards the end, Maya was not doing well at all?
No, I would disagree with that.
Okay. Well, let's take a look again at 1002-0188. And at the bottom there, you note the impressions, I guess, as she's leaving. It's the last one. And does it say chronic pain there?
I believe this is the same treatment diagnosis that she had the entire time she was at the hospital.
Abnormality of gait and mobility, right?
Yes.
Abnormal posture, right?
Yes.
Weakness, right?
Mm-hmm. As I mentioned with the prosecutor or with the defense, like many things improved. We did not get her walking, which was my goal. Right? I wanted her to walk out of the hospital. She still had physical therapy goals to achieve, but some things did improve.
Well, insofar as all the diagnoses when she came in, physical diagnoses, your analysis, it was the same. Chronic pain, abnormality of gait and mobility, abnormal posture, weakness, correct?
The treatment diagnosis was the same, yes. And we were still addressing all of those in all of our sessions.
Now, she also gave you visual confirmation that she was in pain, did she not?
Sometimes.
She would wince?
Sometimes.
And she'd tell you she was in pain?
Also sometimes.
And she would try on many different types of therapies, right?
She tried what she was agreeable to. Frequently on pretty much every session, I would ask her to do things, and she would refuse. And I wouldn't push her past that point of what she refused to do.
Because she would say she was in pain, right?
That's one of the considerations.
And by the end here, she had been some 2.5 months away from the pain medication that helped her, right?
I have no knowledge of that.
Okay. Well, Maya tried as hard as she could, did she not?
I believe she tried as hard as she could, but she often refused and refused to accept any education on physical therapy treatment, and she wouldn't push herself past a point that she was comfortable with.
Do you think that's because she'd already been through all of this before at Tampa General Hospital?
I can't say what she was thinking.
Could it possibly be because this 10-year-old little girl had already been through all of these exercises and had people tell her, no, you can do it, when she knew she couldn't physically, at least without overpowering pain? Is that possible?
Objection calls for speculation.
Sustained.
Let me show you video of Maya at TGH. If we have it there. I'll represent to you this is at TGH in the summer of 2015.
Alrighty. There she goes. She's getting up. There she goes. You up right there? There we go. Okay, come on, left. Let's go. You don't believe me? Too bad. Let's go. Come on, left. There it is. That was great, Maya. Come on, good. Love it. Yeah. Very good. Very good. Maya. Very. Giddy up, Percy. Giddy up, Percy. Giddy up. You don't believe me? I do. Come on. Good, good, good. Woo! Good. Good. That's it. Maya, that's awesome. Very good. Okay. You almost my mommy. Almost there. I was going to tilt her that way. Yeah. There we go. Here we go. You both are getting a workout, aren't you?
Okay.
Yes.
Would you agree with me that that little girl's trying?
Yes, sir. I would.
What are those boots she has on?
Those are called AFOs, ankle foot orthoses.
And why are they put on?
Those are put on to help her foot stay in a flexed position in order to help prevent foot drag or trips and falls.
Well, the jury's seen multiple photographs of Maya Kowalski's feet in that position. Are you still contending that she did not have the dystonia in her feet through the entire time she was there?
So my experience with dystonia is them being in a down position. Just being in a down, relaxed position is not dystonia. That's what we call either foot drop or a muscle weakness in the muscle that's in the front of our leg. Dystonia is something very different, having to do with the muscle and the neuro relationship causing the foot to maintain in a fixed position.
So Marissa Higgins at TGH and those doctors there, they were not trying to treat dystonia with those boots.
Objection, having witness comment on the opinion of another.
That's not comment.
Sustained.
Well, why is it that every other therapist has testified saw Maya with dystonia both before and after her Johns Hopkins treatment, and you found there is none?
Same objection, also calls for speculation and lack of foundation.
Sustained.
How could it be that in October, from June, July, August, September, and into October, those physical therapists found that she did have conversion? There's photographs of conversion. And then after Johns Hopkins in January, through the next 4 months, there are photographs and physical therapists that have testified that she had this dystonia, and yet she did not have it in the period that you had her.
Same triad of objections, Your Honor.
Sustained.
Is it more likely that you're describing dystonia but trying to describe it as it's not dystonia?
No, sir. My experience with Maya was her feet were always in a down, relaxed position. And if they were to touch the ground or move on the ground, her ankles were flexible. My experience with dystonia is once your feet are kind of locked in that inward or down or outward position, very little can be done to help move them. Even maximal force to kind of move it out of that position can be very difficult. Whereas I always observed her with her feet in a down, relaxed position.
So you're saying you think Maya was trying to keep her feet in that position?
No, sir, I don't.
All right.
That's just the relaxed resting position of all of us.
In point of fact, Maya, you were looking, I guess, for signs of paralysis.
I personally I don't recall looking for specific signs of paralysis. My job as a physical therapist is to assess the patient and to find those limitations, whether it's a weakness, decreased range of motion, movement deficits, and come up with a treatment plan to treat those deficits, not to make a medical diagnosis.
Do you contend that CRPS, one of the symptoms is paralysis?
With my experience with CRPS, paralysis is not a symptom.
And Maya never contended she couldn't move her extremities, did she?
When I would ask her to do something like a leg kick, she would say that she can't.
Because she was in pain that day, right?
Yes, that was part of it, and part of it is she just said she can't.
And you disbelieved her, though, on many occasions. True?
I never disbelieve any of my patients when they say they're in pain. I take that at face value.
All right. So she was then in pain. Sorry, Judge. And is it true that by the time she left, she had to slump over in her wheelchair?
Not by the physical therapy documentation.
Well, let's look at, if we can, 1001-1870. And I'll represent to you that this is your note from January 4th, 2017. You recognize it?
I'll need to review it shortly, but yes, it's my note.
Mm-hmm. And in the third sentence, does it say that the patient slumped over in her wheelchair?
This is effective
this
cross,
was
but it's
the
25
very beginning
minutes.
of the session where we sat on the side of the bed, and while we were getting prepared to get into the wheelchair, she had slumped to the side.
I just asked you, it said she was slumped to the side in her wheelchair.
No, sir. It says she slumped to the side on her bed.
Okay.
Anything further, Mr. Hughes?
Yes, a few follow-ups. Mr. Cecil, do you remember Mr. Anderson asking you some questions about whether or not Maya Kowalski improved over the course of her physical therapy treatments with you?
Yes, sir.
Can you please describe to the jury the type of improvements that you observed over the course of the approximately 3 months that Maya Kowalski was in the physical therapy service at All Children's Hospital?
Yeah, so we, like I said earlier, there's 3 main areas we saw significant improvement. One was that sitting balance, ability to sit independently in a wheelchair, participating in activities. We saw it in the video of her playing the piano. That was consistent throughout the time she was with us, especially near the end. The second was her posture. She improved from this slumped, assisted posture to an upright posture with no assistance, no visual or verbal complaints of pain during activity in that sitting position, oftentimes smiling, having fun playing games, or talking about things that she enjoyed. The last one is her activity tolerance. So going from being able to do 1 to 2 minutes of sitting with assistance in severe pain to doing enjoyable activities, including in the documentation we oftentimes got from her wheelchair down to a play mat. And she laid on her stomach, propped on her elbows with her back extended, reaching and playing with games, or different various positions that she would be agreeable to, that we would try. So all three of those areas we improved. I wish that we could have progressed her more into standing and walking. Like I said, that was the big goal, but we just didn't get there.
Mr. Cecil, do you recall being asked by Mr. Anderson about some documentation you had of quadricep spasm, I believe?
Yes, sir.
And that was during passive motion, I think you said?
That's correct. That's what the documentation said.
Now, I think you also said that spasm can be a sign of weakness. Did I hear that correctly?
Yes.
Objection leading.
Let's hear the next question.
Sure. In your experience as a doctor of physical therapy, can the fact that a patient has been in a wheelchair since, in this case, July 4th of 2015, be the type of weakness that could lead to spasm?
Objection leading. Yes or no answer?
Overruled. You can answer that.
Yes. Knowing her history and that she hadn't walked for such a long period of time, that by itself, when you move that leg or when she tries to move that leg, it can cause muscle spasms that will then cause pain. I equate it similar to a patient after a big knee surgery, like an ACL surgery or something like that. You start moving that leg, it's painful because we're moving it, but also you can see these muscle spasms because we're moving that muscle that hasn't been moved.
I'd like to draw your attention to your what I believe to be your final physical therapy note of July 4th of 2017. It's in evidence at 1001, 1870.
July 4th?
It is, I'm sorry, did I say it's January 4th of 2017. This is at Johns Hopkins Children's Hospital. January 4, 2017. Do you recall I attempted to ask you about this earlier? And I completely butchered the question. Do you remember that?
Yes, sir.
Yeah, okay. I'd like to draw your attention to under assessment and goals. There's a line that says she displays the functional strength, and we'll highlight it for you. I'm going to read it out loud. But if you could please highlight where it says she displays the functional strength to complete tasks. And that is the highlighted section there. So take a moment to please review that highlighted section and explain to the jury that after the 90 days in your service, what does this statement mean at the end of your therapy with Maya?
So functional strength is the strength enough to perform activities. Do you have the strength enough to sit, to reach, to do those things? Throughout all of these notes, it's noted that she has strength to reach, to hold herself up, even when stimuli is presented to her, reaching for a game. In one of my notes, something fell on the ground. She bent all the way forward, grabbed it from the ground, and returned to a sitting position independently with zero assist. So she has the functional strength in her core and her arms to do all of these things. And when she's distracted, she does them. She reaches, she leans, she saw in the video, she even moves her legs a little bit to reposition herself. But then when asked to perform specific activities, the things that we're trying to improve, she actively presents with impaired function, meaning those things we just saw her doing with that functional strength, now that the attention has been brought to it, she's no longer doing those things. And that's a consistent inconsistency that we found throughout her time with us.
Mr. Cecil, thanks for your time. I don't have any more questions for you.
I just have one, because that wasn't in fact the last one of the physical therapy reports, was it? Did you have one more on January 11th, 2017?
I don't recall.
Okay, let's take a look. It's in evidence 1002-0185. Now, to take a look here and tell me, would you agree with me that since Maya's admission, she was doing progressively decreased activities independently, including what? Did that include propelling her wheelchair? Did it include lower
I don't see my
extremity
name on. I
exercise?
don't see my name on this page anywhere. I just want to make sure this is my documentation.
Sure.
I don't want to speak on something that's not mine.
Yeah, the previous page I think shows it. But,
okay, thank you.
okay, so are you noting here, or I guess the PT department, I think it's you, noting since admission she'd been performing progressively decreased activities independently, including propelling her wheelchair, lower extremity exercise, and participation in physical therapy tasks?
Oops.
I think my documentation shows that I never documented seeing her propel her wheelchair. That might be in reference to someone else's documentation, but her participation in physical therapy tasks definitely decreased, as I mentioned before. And her lower extremity exercise decreased because she was refusing to attempt a lot of passive movement, me doing it, any active movement, or even attempts at standing, like you said.
All I was asking you is whether you put down here on her very last visit that her performance was progressively decreasing. And that's true. That's what you did, isn't it?
In these three areas, it might have decreased. In those other areas, there was a significant increase.
And anything else to use there? Members of the jury.
Judge says it's probably going to be 20 minutes before we can get back to you. Do not discuss this case. Jurors exiting.
Members of the jury, I'm going to send you back. Now, I will tell you after I review these questions with the lawyers, we will then take our break. So it's probably going to be 20 minutes before we can get back to you, okay? Do not discuss this case.
Judge says, okay, the jury is out of our presence. Doctor, we're going to go through these questions outside your presence, so I need you to be outside. You're in the middle of your testimony, so when we take our break, you will not be able to talk with the lawyers or anyone else. Okay? Thank you. Feel free to go use the restroom and take a break. Okay, says the judge.
Out of our presence, Doctor, go through these questions outside.
Red number 1. Dr. Cecil is out of our presence, says the judge. Red number 1. In the video, it seems odd that you were trying to make her stand up without some equipment or warm-up. What was the date of this video? That's what that one looks like. Doesn't it seem reasonable Maya would be moving or sitting better during piano video, given it was December and she would have had numerous PT sessions? 3, did you think that her lack of participation was due to her growing depression with being away from home? 4, is distraction a typical tool to use in PT with children? 5, what was the date of the video of the piano? Mr. Anderson says, the date, we can tell him that. Because we can calculate it was during the... No, it wasn't. Mr. Hughes says, I don't know the answer. Mr. Anderson says, let me see if I can see if I can find it. Mr. Hughes says, I don't think we do. Shapiro says, there's no objections to the question, but I think if Mr. Anderson can find out the date, we'd be happy to just tell the jury the date. No objections. Judge says no objections. Over break, the date of the 2 videos. Miss Lawrence, if you could work on the date of 2 videos over the break, thank you. Red number 2. Before hearing from Maya, had you had any formal training provided by Johns Hopkins on CRPS? Before caring for Maya, how many CRPS patients had you cared for? Is it more common to have a spasm with passive movement on a limb that has not been moved in a long time? Shapiro says no objection. Mr. Anderson says no objection. Red number 3. Other physical therapists that worked with Maya indicated and testimony that CRPS patients find cross legs position, crisscross applesauce, the most comfortable for that condition. Is that not your knowledge with regard to that leg position? No objection, says Shapiro. Red number 4. I see in your note, and it's in parentheses, the first note shown to the jury, and it looks like December 1 is the 2016. I see in your note, your document, quote, transfers to and from the couch with max assist, end quotes. Can you please define max assist to the jury? It's also documented on her note in January. Did you have any interactions with Kathy Beatty regarding Maya's care? If so, how often? Did you attend interplanetary rounds on Maya? What team members were present for this meeting? How often did these occur? Were you aware if upper senior management was aware of Maya being in your hospital? We heard testimony Maya was a fall risk. Is the policy at the hospital to use a gait belt when transferring children with a fall risk at the hospital? No objections, says the lawyers. Something about the nurse. The judge says the exhibit 1002-0188 that read conversion disorder as a treatment diagnosis had an admitted date of 1/6/2017. Do you know that this diagnosis was listed on the previous admitted date, October 7th, 2016, when you first started the therapies? That's aggressive. That's impressive, says Mr. Shapiro. And the judge says, so is this jury. No objection from either side. Judge says they're asking lots of questions and they're very detailed. They're reading everything. Shapiro says that's a very alert question. Judge says, so what's this person's name again? Cecil. William Cecil, says Hughes. Judge says, I'm just putting Cecil. So when they go into the record, hopefully there's some ability to keep. We've got 2 Cecils, says Hughes. Apparently, says the judge, there's a page order. It's talking about filing the notes. Red number 6. Dr. Cecil, back in 2015, when you were employed by JHatch, you were, yes, very book smart, but in gamers' terms, you were a knob, a noob. He says knob. Judge says, is it noob? I don't know. Everyone's like, noob, it's noob. Newbie. Everyone's laughing. Judge says, I'm not a gamer. I'm sorry. Anderson's like, I love it. I'm not either. Judge says, is it noob or newbie? Hugh says, it's a newbie. That is priceless. Are we going to get the Urban Dictionary out, says Hughes? No. Now, says Judge. Now, 8 years later, you testified what therapies you used for CRPS. Now, today, or, quote, the same, unquote, that was used in treatment for Maya back then. In 8 years since Maya, you're saying there has been no improvement in the therapies used for CRPS patients? Is that to say within 8 years, nothing changed because what was done 8 years ago is still the best darn thing since sliced bread? Or is it possible because CRPS is still poorly understood, as past doctors testified, and for that reason, the acceptable therapies too have not advanced or been advanced to treat CRPS patients? What are your thoughts? Shapiro says, my general comment, I don't know how to handle it. I know that they're trying to object some humor, but at some level the questions have to be relating to admissibility. Let's see if we can relate this into something that's admissible. I think he wants like the sliced bread things cut out, maybe noob as well. The transcript's going to be hilarious. It's very quiet right now. Defense team's muttering quietly to themselves. Mr. Anderson said, let's see it. Shapiro says, I'm not trying to be sensitive. I know it's funny, but I do object. So we're trying to see where we can insert a correction. Anderson says, well, he's book smart and he's a newbie. Ms. Shapiro says, we'd like to rephrase it. You're new to the position. Mr. Anderson says, I think it's a great question based on the witness's answers to his training as to CRPS and how long he's been doing it. Anderson says, I didn't see leading as insulting. Oh, never mind. Shapiro says, can we just rephrase it as new to the position? I just don't think being called a noob. Maybe I'm being sensitive. Carell says, newbie. Judge says, I am fine saying new to the position. The judge says, red number 7. And just so the transcript's clear, red number 7 is 2 pages, but it says page 1 of 3 and 2 of 3. So red number 8 will page 3 of 3. Just so anyone that's keeping track on this record, which I'm sure is going to the appellate court, will be able to know what we're talking about. It is going to the appellate court. Judge says, I just feel sorry for the law clerk. Okay. Dr. Cecil, you stated that first Maya was 5 or 6 times a week for therapy, correct? Then, as time went on, it was lessened because Maya refused or couldn't do it. Refresh my memory, please. Was it refused or could not? Next question. Would not have been a result of Maya's CRPS affecting her physical or mental abilities and therefore her performance? Next question. You, parentheses, and this juror, end parentheses, are not psychiatrists, but we are humans and have feelings. How a person feels can have an effect on their abilities. Recalling Maya was 8 years old, is it possible that Maya's weaning abilities could all or in part be attributed to what J. Hatch was causing? The limiting of family interactions, the stress and trauma Maya has testified to, documented statements to Maya about her mother's status, told to Maya by hospital staff, Miss Beatty. Could all this possibly have affected Maya's participation in your therapy sessions? Yes, no, comment. Here are the pages. They say, it's what Miss Beatty did. This is just me now. Shapiro says, no objection. Ms. Corrales is whispering something to him. Mr. Anderson says, I have no problem with one. Okay. Both say, no objection number 2. Shapiro says, we object to number 3, and we do have grave concerns about this particular juror now expressing opinion that all children's is responsible for the parents being separated. He specifically says in this question, could all this be all or in part be contributed to what JHCH was causing? The limiting of family interactions, the stress and trauma of Maya's testified to. Documented statements, says Curls. Documented statements, says Shapiro. These are all are going to go into DCFS questions. And again, all Children's Hospital is not responsible for the separation of Maya from her family. We object to the question. Anderson says, hey, hang on. I didn't read it. Judge says, well, first off, it sounds like no objection to 1 or 2, right? Correct. So we're just talking about question 3. Whitney says, each of the specific things and the specific allegations, they don't reference a shelter order. They reference a specific actions of Miss Beatty. If there is one of those 4 is cause for objectionable, we could strike that and leave the rest. The rest are directly related to our. And the judge says, yeah, and Anderson says, and what he's saying here, the limiting of family interactions and stress, the trauma Maya has testified to, there's nothing wrong in that, because that's what Maya testified to. That he's referring to what's documented about the mother's status. Kurils says also staff Miss Beatty could have affected Maya's participation. I also believe this is showing incredible bias by this juror not waiting to hear all the evidence and already made a determination. The judge says, right now we're talking about question number 3. Shapiro says, the defense objects on multiple grounds. The primary one, this is the question, implies all Children's is responsible for the separation of Maya from her family. It implies that all Children's is responsible for interference with the relationship between Maya and her mother, all of which is subject to court order. And we believe, again, it's objectionable and also shows that this particular juror has prejudged the evidence, especially in light of the fact that the court is going to soon instruct this jury on the time frame that the orders that we're not responsible for. Hughes says, also foundational issue, the witness has been asked to testify about psychological items as well as evidence he correctly has no clue about and hasn't been here and doesn't know anything about. Kurils says, can I just say automatically this juror is telling all other jurors what he believes the evidence is in that question. And Anderson says they're all doing that. The judge says, I agree with Mr. Hughes. There's not any foundation for his testimony because he's not a psychiatrist. I'll sustain on that basis, Mr. Hughes. And so I'm going to not ask number 3. That was it. Judge says, and I feel sorry for the law clerk on it. Both sides have said they're appealing this regardless. Kurils said, we didn't take that in any way. Somebody says, I was kidding that. Counsel break? Judge says, do you need 5 minutes or 10 minutes? It's fine. It's 3:40 at this point, says the judge. I don't know what you have next. Kurils says, well, we can tell the court we have a deposition of Dr. Malik. It's 55 minutes long. Judge says, let's take 5 minutes. Kurils says, we also want to polish some things too. Judge says, 5 minutes. We're going to be in recess 5 minutes. All rise. Court is now in recess. Whew, that was a long one. I love being able to hear the questions that don't get read. Oh my goodness. That's beautiful, beautiful stuff. Let's see. I got behind while I was watching on 1.5 speed, and the feed just caught up in Recovery Addict. Sounds like he's in slow-mo. The questions are difficult because the judge also is trained to decipher handwriting, which apparently is not the neatest for many of these jurors, and so he's reading haltingly. So it sounds a little funny that way. I think we've got Jules on the phone. Hold on just one second, see if we can bring her on.
Call from
Jules.
Jules, are you there?
I am.
How are you doing?
The tension was so thick in there you could cut it with a knife. With the previous witness, I think, in my opinion, and I'm no lawyer, you all know this, I think Mr. Anderson was able to recover on that previous witness, but time, I'm not going to lie, time is now becoming a concern for me. Up until yesterday, I wasn't concerned. I'm starting to be concerned on the time. With this witness, come on.
It's a lot of time. Mr. Anderson used 24 minutes in cross, almost 25 minutes in cross of this witness. The previous one he used just over 30. Before that, he used 12 minutes and 45 seconds. He's over an hour already today, and he only had 6 hours and 20 minutes to start at the beginning of today.
Exactly. And so I'm getting concerned because you know who is going to be up tomorrow.
Yes, we're going to get Sally Smith tomorrow, Miss Beatty on Monday. Both ones I think the defense or the plaintiff needs to cross-examine.
Absolutely. And I don't know if you heard, but both sides asked for extra time for her.
When was that? I did not hear that. For Sally Smith?
For Sally Smith, yes. They asked, both sides asked for extra time for tomorrow for Sally Smith.
Interesting. I did not catch
crap.
that. Okay.
Are you still?
I'm here. What's up?
I lost. Oh wait. Are you there?
I'm still here. Yep.
All right. I thought I lost my connection. So yeah. So I am getting like super concerned because I love Greg Anderson to death, but the time is crucial here. So
he's going to have to make some hard decisions.
So
I'm hearing a lot of feedback right now. Are you hearing that?
No, I'm not hearing the feedback.
Okay. We did hear a little bit of from Mr. Anderson. There was a point where he was talking to, I believe, Mr. Whitney and said, well, you can cry about it if you want. Talking about Mr. Whitney had apparently complained about the questions he had not asked or questions he had asked. We can only deduce that has something to do with time as well. Mr. Whitney's like, save me some time. I'm going to need some as well, right?
Yeah. Yeah. And like I said, the tension today on everybody's part was intense.
Yeah.
Both sides and within each other. But I would like to emphasize, especially by this last round of questions, this jury is not stupid because they are bringing up in their questions things that I forgot about.
Yeah.
So
they're bringing up evidence like the stamp numbers. They've got details. They've got dates. They remember where they are in the evidence and what came before it. It's incredible how sharp they are.
They are. They're very, very sharp. And judging by Shapiro's responses to the judge, yeah, I'm sorry, Mr. Shapiro, but you are acting like a crybaby. You are, in my opinion. And
it's his job to cry. Yep.
I get it, but you know what? You can't turn around and say, well, this juror is biased. Dude, you were there during jury selection. You were there. You asked questions. you did this, and now you're going to say that this particular, and I don't know which juror it was, okay? I can only tell you which jurors submitted questions, but that particular question that he was, moaning about, I don't know which one it was, but the juror questions for this witness was 1, 4, 5, 7, and 11. Okay. So I don't know, but my point of it is how could you stand up there at the bench and make these statements that this juror is biased against them? You did voir dire.
Yep. Jules, the judge is back. I can see him on Zoom, so we're going back on. We'll catch you again. Thank you so much for the update. All right.
Judge, I misspoke. Just for the judge, for the court, the maladeb is 58 minutes and 5 seconds.
Well, you owe me 3 minutes and 5 seconds.
Just let you know, because I don't know how long the question is going to take.
Well, and this is the one that was 2 hours and something?
It was.
Yeah. That's progress. I'm very pleased about this. There we go. Anything before we bring in the jury?
We have the dates of the videos, Your Honor, if you want those.
What are those, and you want me to just announce them?
I'm sorry.
What? Not the TGH video? Or are you talking about the info too?
We have the date of the TGH video. It's August 14th, 2015. The EEG video when he's transferring her into the wheelchair is October 20th, 2016. And the piano video in the lobby is January 3rd, 2017.
Okay. And you want me to just announce those dates to the jury?
Yep, no objection.
Okay, let's bring in the jury. Let's bring in Dr. Cecil.
Make sure we get Jules as well. She's there in the hallway. I saw her through the door. I really, I'd like to know if the defense used all their preemptive strikes on this jury selection. If somebody can go back and find out, did the defense literally, are they objecting to this jury? We've seen that happen before. Or did they have objections and they said, no, we're good with who we have? Or, I mean, did somebody sign off on this and think, yeah, we've got enough the right people here? Okay, the doctor is going to be back on the stand, or the physical therapist, I should say. Doctor of physical therapy.
I want to confirm, while you're away, you did not discuss this case amongst yourselves, you did no investigation, and you received no information. Is that all correct?
Correct.
And no media, correct?
Correct.
No one approached you, correct?
Correct.
In the questions, there was a request for the dates of the various videos that were shown to this witness. And I'm just going to tell you the dates of those videos. The Tampa General Hospital video was August 14th, 2015. The EEG video was the October 20th, 2016. The piano in the lobby was January 3rd, 2017. Members of the jury, I went over these questions with the lawyers outside of Dr. Cecil's presence, so this will be the first time he's heard these. In the video, it seems odd that you would try to make Maya stand up without some equipment or warm-up. There was also a question about the date of this video, so any comment on that statement?
Sure. So I think that video was one of the very first times I met her. So what's not shown in that video is probably what we did in bed, if we did any activity in bed, trying to assess where she was at that day. I don't know for sure. I can't recall exactly, but once we sat edge of bed, as we talked about, she wasn't kicking her legs, she wasn't moving her ankles. But what we did see in the video is once we were sitting edge of bed, she was interacting with us. She was pleasant, And when we were ready to complete that transfer, we call it a stand pivot transfer, going from one surface to another via a pivot. She leaned forward and leaned into it and participated with us. Yes, she needed a lot of assistance, but she was actively participating in that transfer. So what we did before that moment, I can't recall exactly, but doing that transfer, she was actively participating in that and willing to do so.
Does it not seem reasonable Maya would be moving and sitting better during the piano video, given it was January 3rd, 2017, and she would have had numerous physical therapy sessions?
Yes, exactly. I think that's exactly the point, is that we've been working with her that entire time, working on sitting activities, so it's entirely reasonable that her sitting is better, because that's a lot of what we worked on. We were working on core strength, core stability, sitting balance, dynamic sitting balance. So I think it's entirely reasonable that by January that it improves, because that is the majority of what we were working on.
Did you think that her being Maya's lack of participation was due to her growing depression with being away from home?
I'm not a psychologist, so I don't know that I can comment on depression or anything of that sort. I think that's outside of my scope of practice. So,
is distraction a typical tool to use in PT with children?
Yes, I think it's one of the most common tools that we use. Sometimes we see kids of all ages, and when we're in the hospital, they're focused on a lot of the things other than what we want or need them to do. So for Maya, we use distraction to get her focus off of the pain and onto an activity to improve her strength and function. For another patient, say like a 3-year-old who has cancer, we might use play as a distraction. Instead of, we're not going to engage in conversation with a 3-year-old, but we're going to present toys that they enjoy or an activity that they enjoy at home in order to distract them from all of the lines and tubes and everything else going around them in the hospital, to focus on the task to improve their function or whatever their goals are.
Before caring for Maya, had you had any formal training provided by Johns Hopkins on CRPS?
Yes, I had. So when I was a student, I had a clinical internship at Johns Hopkins, all children's in their outpatient sports clinic. And during that time, we had seen several CRPS patients. So at that time, I was under the clinical supervision of a licensed therapist, and we had frequent discussions about what proper treatment is for patients with that condition. Also, when I became licensed and got hired as an employee at Johns Hopkins, when you're a new employee, you have clinical mentors who you can throw ideas off of, treatment ideas, things like that. As was brought up, there was another PT who was also treating Maya at the same time, so we would frequently go back and forth with treatment ideas or techniques or things that we could try during various sessions. So there was a significant support in training, I feel, prior to seeing Maya.
Before caring for Maya, how many CRPS patients had you cared for?
So prior to seeing Maya, I had finished that 4-year degree in physical therapy school where we talk about chronic pain. We talk about CRPS and proper treatment. I had seen 2 or 3 maybe during my clinical internship, maybe 4. And then while I was licensed before Maya, between my outpatient experience and inpatient experience, it was probably around 5.
Is it more common to have a spasm with passive movement on a limb that has not been moved in a long time?
Can you repeat that one more time? Sorry.
Is it more common to have a spasm with passive movement on a limb that has not been moved in a long time?
I don't know that it's more common. Spasms can be caused by different reasons. So passive range of motion is, like I said, the patient doing no active movement, right? They're not squeezing their muscle. They're not activating any of their muscle fibers. It's simply the therapist lifting their leg, working on range of motion, usually of a joint. So like I said before, if you're weak in that leg or that muscle's not used to extending and flexing with what we're doing, it can cause a spasm. But also, with active range of motion, those can cause spasms too. And there are other reasons that spasms cause with no motion. My work with Maya, from what I recall and from the documentation, that's the only spasm I noted. And the 20 hours I spent with her, 21 sessions, that was the only time I documented on a spasm. And I don't recall any other active or passive spasms during my time with her.
Other physical therapists that worked with Maya indicated in testimony that CRPS patients find cross-leg position, crisscross applesauce, the most comfortable for that condition. Is that not your knowledge with regard to that leg position?
So my experience with CRPS over the last 9 years is that it's highly variable. CRPS can affect any limb of the body, in any joint of the body. So, and that allodynia, that hypersensitivity to touch, can be in various areas. So it's really highly dependent on where the patient is having their pain, what it feels like for them, and then what their comfort positions are. So I don't know that I could say in general that crisscross is a overall general comfort position for patients with CRPS. If I have a patient with a CRPS of their elbow, they're not going to have a problem getting into crisscross. But if I have another patient who has CRPS of their knee, or in their knee, crisscross may be very difficult, or it might be that comfort position. It's highly variable how these patients present. So I wouldn't say, I can say in general that that's a comfort position in general for CRPS patients.
I see in your note from December 1st, 2016, and then also documented in January, that you documented, quote, transfers to and from the couch with max assist, end quote. Can you please define max assist to the jury?
Sure. So in therapy, we use different terms to describe how much assist a patient needs. And it's a scale. So max assist would mean the therapist is providing 75% and the patient is providing 25% of the effort, or of the effort to complete that task. So 75% total assist would be 100% for the therapist. Mod assist, as I said earlier, is 50-50. Min assist would be 75% for the patient and 25% for the therapist. And then we use words like contact guard assist, which is just like holding their hand or holding their back for support, or standby assist, which is being close and monitoring, but seeing them do it by themselves.
Did you have any interactions with Kathy Beatty regarding Maya's care?
I remember working with Kathy Beatty. I don't remember having any conversations specifically with her about Maya.
So you wouldn't know how often those interactions were?
No idea.
Did you attend interdisciplinary rounds on Maya?
I remember having many communications with various providers about Maya and her case and how she's presenting, and kind of giving my input. I don't recall attending any specific interdisciplinary rounds where everyone got together.
So if you don't recall, then you wouldn't know who was present.
Correct.
Okay. Were you aware if upper or senior management was aware of Maya being in your hospital?
I have no reference to know whether they did or didn't.
We have heard testimony Maya was a fall risk. Is it a policy at the hospital to use a gait belt when transferring children with a fall risk at the hospital?
There are various thoughts on gait belts, whether they're helpful or not. I believe after this video, we did have gait belt on her frequently. I think during the video you saw, I didn't have a gait belt because that was one of my first times seeing her, and I was assessing what she was able to do. Still providing the proper assistance to make sure she didn't fall. She was safe, monitored. But afterwards, I do believe we had a gait belt on her when we brought her down to the therapy gym and things like that.
The exhibit 1002-0188 that read conversion disorder as a treatment diagnosis had an admitted date of January 6, 2017. Do you know if this diagnosis was listed on the previous admitted date, October 7, 2016, when you first started therapy?
I don't know off the top of my head. The way those medical diagnoses are viewed from a physical therapy perspective is that doctors make those medical diagnoses, and they end up in our chart based on what the physicians consult us for. We're a consulting service, so in order for us to come see a patient, the physician has to consult us to come and work with them. My treatment diagnoses under that are the physical therapy treatment diagnoses, the things that we're trying to improve. I think that answers the question.
Next question. Back in 2015, when you were employed by Johns Hopkins Children's Hospital, you were very book smart, but you were new to the position. Now, 8 years later, I believe you testified what therapies you use for CRPS today are the same that was used in treatment for Maya back then. In 8 years since Maya, you are saying there has been no improvements in the therapies used for CRPS patients, and that's a question.
So the conservative physical therapy treatments that we use for all CRPS patients are research-based. They're contained, and research is shown within what's called the clinical practice guideline, which is held by the APTA, which is the American Physical Therapy Association, which is the national organization over physical therapy. So they have it's called a clinical practice guideline. It's a collection of the research that shows that physical therapy treatment, various physical therapy treatments are effective and beneficial for the treatment of complex regional pain syndrome. Every so often, no new research comes out. To my knowledge, the graded exercise that I've talked about all day today, that, based on how the patient is doing, pushing them within their limits to do as much as they can, grading them up to do more, grading down if it's a day where they're having more pain or more complaints. That is the standard for physical therapy treatment. We have options within there like therapeutic exercise, working on ADLs, things like neuromuscular re-ed, which is kind of making the connection between the nervous system and the body in order to improve the function. But at the end of the day, the big goal of physical therapy, what you're trained to do in school and in your internships and in your training on the job, is to find those impairments, find those difficulties, the range of motion, the strength, the walking, and then develop a treatment plan to improve those things. And that's exactly what we did with Maya. Our treatment plan, the treatment plan I wanted to perform with her didn't go exactly as we wanted, right? As I said before, she wasn't walking when she left, but we did things every single session that was inside that clinical practice guideline in order to help her improve in her function.
Dr. Cecil, you stated at first Maya was 5 or 6 times a week for therapy. Is that correct?
Yes.
As time went on, it was lessened because Maya refused or couldn't do it. Refresh my memory. Was it refused or could not?
It's a combination of both. She, at the beginning, if you're reading through the notes, the first several times I saw her, we were attempting to stand. We were, supported standing with assistance in order to start building strength in our legs and to tolerate standing more. The goal of those sessions is to work through the pain in order to become more functional. Oftentimes what we see in chronic pain patients, CRPS and other chronic pain, is that function improves before pain improves. And that was our goal, is to improve her function. That's the physical therapy goal, is improve her function. So as we kept going, her function was improving in some ways, but in the areas that we wanted to see improvement, the standing, walking, participating in those things, she was flat out refusing, which we were never going to push her past and into something that she was refusing to do. We were never going to make her do something that she said she couldn't do. When she was agreeable, when she would take in any education and participate in things that we know would be beneficial, then we would do those things together. But at the point where we decreased her from that 6 times a week to 3 times a week, we had gotten to the point where it had been several sessions where we had plateaued and not made any progress. We had reached those goals that she left with. So that's why we decreased her, with that knowledge of if she can start doing more, if during those 3 times a week that we're still seeing her, she can start doing more, she can show us that, hey, look, I can move my legs a little bit, I can tolerate it, I want to try, I'm not going to refuse, then we would have immediately moved her back up to a higher frequency and seen her more often.
Could this, quote, could not, would not, end quote, been a result in Maya's CRPS affecting her physical or mental abilities and therefore her performance?
Do you mind repeating that one more time?
Could this, could not, would not, been a result in Maya's CRPS affecting her physical or mental abilities and therefore her performance?
Certainly her medical condition affects how she's going to participate, how she's feeling, how she interprets her pain affects how she participates in therapy, 100%. Her mental capacity, that's outside my scope. I'm not going to comment on that. But our job as a physical therapist, as I mentioned, is we're going to grade what activity we do. Like I said, grade up, grade down based on how she's feeling and her feedback on certain activities. So if she, I think there was a good example in there of sitting in her wheelchair, she was doing well, we were doing things, and I wanted her to transition to a chair that had no arms. I had seen her sitting in her wheelchair without using the arms, so I was like, oh, let's transition, maybe a stand pivot, maybe a scoot into this chair that has no arms, and then continue doing what we're doing. But she would say she couldn't do it, she refused. I would try to educate her on why that's important and how, hey, it's the same, it's just another chair without arms that you're not using anyways. But I didn't make her do it. If she refused and said she couldn't, or she was fearful of falling, even with me there guarding her and protecting her, we didn't go there. We didn't do that.
Mr. Hughes, any follow-up?
No, thank you.
Mr. Anderson.
You testified that the only time you had noted muscle spasms. Can we look at 1914? Top of the page.
He said that was the only time he documented muscle spasms. So here we go. Let's see if there's another. Boom.
See right there in the top.
Can you go to the previous page so we can see the whole sentence?
Page 5. think he wants to see the page prior. Is that you?
Yes, sir.
Let's look at.
She displays muscle
1947.
spasms of quads. What was in there?
Second from the bottom. Well, third line from the bottom. 1947. It's actually second line, yeah, from the bottom. Yep.
She began to have apparent muscle spasms in her quadriceps.
Oh, there you go.
When asked to,
Okay.
asked to complete a lower
Is that
extremity
you?
exercise.
Yes, sir.
3 times that you noted muscle spasms in her legs. Is that right?
Yes, it is.
And when you started out, she was receiving some pain meds, but then you stopped those as time went on, right?
I don't have anything to do with muscle or medications. I don't prescribe. I don't give them out. It has nothing to do with medication.
Mr. Hughes, anything?
No.
Members of the jury, any follow-up?
Those 3 references to muscle spasms were all worded differently, and they were his personal report.
Are these from subpoenas? Yes, sir. Thank you, sir.
Ken and Ann, thank you for the
members of the
5
jury,
gifted memberships, as well as CG in
understand
Texas. Thank you very
deposition
much for that. Also, we have Cachette, Mission 10. Thank you very much. Very much appreciated, all of you. Judge is stretching. Brief little sidebar, probably a scheduling issue. Mr. Hughes is edging closer so he can hear. Cheryl Arnold, welcome to the gallery. Thank you so much for being here. I know you guys, we've got, chat is going like crazy. I appreciate everyone's attempt to be respectful in all their comments, making sure we don't attack individuals. We don't want accusations flying back and forth. Thank you very much. You guys are doing great, and all I can say is thank you. Thanks to the great mods as well. Thanks to all of you. This is a lot of.
We have about 1 hour video. This is the video that we started the other day that was going to be more than 2 hours, but we've got it down to just under 1 hour. So,
which means,
like I said, just under an hour.
The plaintiff cut
so I say
most of their
we just
designations out.
Do it right now, and you'll get out of here about 5:15. Do you want the lights remain, or do you want them dimmed some? It looks like everyone's. Am I saying everyone wants them up or down? All but one want them up. I'm sorry.
We have division amongst the jurors.
Let's, Ms. Krells, if you could tell us who we're calling again.
Yes, it is the deposition of Dr. Farhan Malik, taken on November 12th, 2019.
No, I don't think he committed perjury. It just shows that his recollection is not as reliable.
Yes. Please state your name for the record. Farhan Malik. And you are a physician in practice employed by Johns Hopkins Children's Hospital?
Yes.
And where'd you go to college?
New York Institute of Technology.
Year you graduated?
2005. 2005.
That water bottle looks cold.
Medical school?
New York College of Osteopathic Medicine.
And where's that located?
It's also located with New York Institute of Technology. They're both in Long Island.
And what year did you graduate your 4 years there?
2009.
For the benefit of the jury, can you give them a very brief description of the differences, if any, between an MD and a doctor of osteopathic medicine?
Sure. The degree is actually called a DO.
Yeah.
It essentially is very similar to MD schooling. You just take additional courses in osteopathic manipulation, which I liken it to chiropractic. And so you have the option of practicing that when you graduate versus just practicing as a regular doctor.
Again, I don't know how accurate this is because I'm just reading off the internet, but osteos tend to be literally more hands-on with the patient. I mean, there's more manipulation and testing, feeling, touching, that kind of thing, and diagnosing?
You take classes in the manipulation aspect of it, and if you choose to practice that, once you're done, and incorporate that into your practice, if you're in a field where you can, such as internal medicine or general practice, becomes a little different when you become more and more specialized.
The area that you chose to go into was critical care with a focus on cardiac, is that right?
Yes, cardiac intensive care.
All right. And where did you do your residency?
Newark Beth Israel Hospital, so the Children's Hospital of New Jersey.
And what year did you, what years were those?
So that would be 2009 to 2012.
And after residency, what did you do?
I did my fellowship in pediatric critical care at the University of Texas in Houston.
Right.
This is mostly going to be defense.
And what year were you licensed to practice
designation.
medicine in the state of Florida?
2015.
This video was edited
So
very
at the
poorly.
time you saw Maya Kowalski in her October 7th admission, you had been a licensed physician in Florida for 15 months? Let's see, May, so 12, May, June, July, August, September. So about 16, 17 months?
Yes, I believe, approximately.
We've seen
You
2
were a
minutes of
fairly
this
young
already.
doctor, relatively speaking, experience-wise.
Yes.
Were you licensed in any other states?
New Jersey.
And what year were you licensed in New Jersey?
That would be at the start of the conclusion of my residency, so that would be 2012.
So after your fellowship at UT Houston, where did you go?
Johns Hopkins Old Children.
And what was your position?
Pediatric critical care physician.
And what does a pediatric critical care physician do?
All things involving intensive care. So if a child gets admitted to the ICU for any number of reasons, trauma, sepsis, after surgeries.
Would it be fair to state then that as of October of 2016, you were not an expert in complex regional pain syndrome / also known as RSD?
Yes, that's very fair.
Would it be fair to say that as of October of 2016, you were not an expert in medical child abuse?
Yes.
You were not an expert in factitious disorder by proxy?
Yes.
You were not an expert in a conversion disorder?
You're listing a lot of psychiatric disorders that, no, I am not an expert in because I'm not a pediatric psychiatrist. So.
Okay. And then Munchausen by proxy, same answer?
Yes.
Not an expert in that either. All right. When was the first time you met Dr. Sally Smith, if you recall?
I don't believe I've actually ever met her.
Have you ever spoken with her on the phone?
Can't recall exactly, but I might have spoken with her regarding this case.
Did you know of her, even if you didn't speak to her or see her?
Yes.
And what did you know of her as of, say, the period before October?
That she was our go-to person to speak to if you had concerns of child abuse.
On any of Maya's prior admissions or visits to the ER at ACH, had you ever run into either her or her family?
No.
So the first time you ever met any of them would have been on that October 7th visit?
Correct.
And do you know Dr. It's Tepes Sanchez, but I think everybody just calls her Dr. Tepes. Is that right?
Correct.
Okay. Did you know Dr. Tepes before this admission?
Yes, we're colleagues.
And how long had you worked together?
A couple of months.
There has to be some structure in your mind about, do I make a call, don't I make a call, or do I recommend a call or not recommend a call?
Part of being a pediatrician, if you suspect child abuse, by law, you're obligated to report it.
So what are some of the things that create a suspicion to you?
Yeah, you need to stop. What's going on?
They just said, you need to stop this. They said, what's going on? Nick the Hat says, hope all's well, my man. Unrelated, but the FBI Pittsburgh and Richmond divisions issued a BOLO. Be on the lookout for 4 escaped Georgia prisoners. Still no sightings. Great stream as always. Nick the Hat, thank you so much, my friend. We found each other during the Cavalcante manhunt. Nick did a great job getting video on the ground and allowed us to use a lot of that, and that was awesome. Nick, thank you for checking in. We are keeping an eye on those manhunts. That is something I like to follow as well. So thank you so much. And great work, by the way, on some of the stuff you're covering, the police, the funeral, everything, incredible photos. I've been watching you on social media. Great stuff over there. I don't know what's happening here. There's an objection about something. These designations, this was rough cut. Usually the designations are played so much better than this. But almost every single sentence, a question is asked and then, sorry, this is failing on me. There we go. Almost every single sentence, a question is asked and then they cut out 1 second and then it responds. And there could have been objection in there, and they might be cutting out that objection. But it sounds like they've just cut and pasted answers together. Like it's almost playing like a bad lip reading type video, where it's like, look what we can make people say by cutting on things, placing things out of context. It is so hard to follow with these abrupt cuts. It's saving a lot of time, but this is now the second time that we've started this deposition and stopped it for some reason or another. So. Look at my briefs. Thank you for the.
Well, we'll just let you go home.
Okay.
Once again.
Do not discuss this case amongst yourselves. Do not do the investigation and receive the information. Now, tomorrow we're going to start 15 minutes later than normal. So I need the jury to be ready to go at 9:15 as opposed to 9. You get 15 more minutes to sleep in.
Oh, very nice.
Never works.
Never works. The jury says it never works.
Have a good night.
Thank you. Good night. Thank you.
Okay, so we might get to sleep in as well. Let's see what happens here. See if the judge is frustrated about this start and stop. This is the second time. Thank you, Nick. Appreciate it.
Thank you all. Please be seated. So we'll try again with this one after we.
Judge, I'm not sure. My apologies to the court. I don't know why where we're at with that, but I will look at what's going on and confirm.
let's talk about what we need to do with the remainder of our time. You were saying something about Dr. Hannah's deposition, right?
Oh, yeah, Judge. I don't know if this was a miscue. Again, everybody's trying to do,
Megan
find
Fox
things.
just
My
rated us with
understanding
the
is we
viewers.
only
Thank you very much,
designated
Megan.
pages in the
Welcome.
2020 deposition that we're going to play. I think the other side maybe was looking at old designations and spent a lot of time looking at the 2022 or 23 dep. But my question to the other side is, time you'll never get back, I get that. We are only playing the 2020 dep. Did the other side also want to play designations from the 2023 dep? If so, we'll look at those.
Yes, we would, because we didn't get a substantive cross until the later deposition.
Okay, so you intended to do those designations?
Yes.
Okay, that's what I needed to confirm, so we would look at those for objections.
And I'd be happy to look at a clip report once it's done to make
Yes,
sure.
I'll be happy to send that to you.
And so do I have, I know I've gotten
Thank you,
two
Megan. So
Dr.
good to have
Hannah
you here.
depositions, but do I have the objections for?
No.
I only have one side's objections.
We haven't seen we haven't had a chance to see their counters, Judge. They just got filed, so we have not looked at their counters for objections yet.
And what time do you think you'll get a chance to do that?
One of us will make it a priority as soon as we get to the hotel, Judge, to look at those if we're leaving early. We don't want to do that as soon as we get back, to look at their counters for objections.
A designation is
Why
what
don't you use the
one party wants
email
played
over the weekend?
Yes.
in a deposition.
And I'll be at a place with no electronic service capabilities until after 10 p.m. tonight.
Judge is going off the
So
grid.
I won't be able to get you anything until close to 10 or around 10 tonight. And then depending on when I get your designations and the volume of it, that might impact the time I'll return it.
It's a 325-page deposition, volume 1. So
we didn't designate that much.
Forewarning.
Just on that point, since I know your shot clock is where it is, we only designated like 15, 20 minutes. Did you designate hours of this?
We designated a fair amount. I can't quantify it.
I mean, okay. Just to,
they have been better this week on usage of time.
Okay. Your Honor, just to piggyback on the last question, we do intend to publish some of the emails that are admitted in evidence, and I hear there is an objection from the plaintiff about just publishing them. We're looking for some guidance. Would they like us to recall our expert, Dr. Crane, or one of our experts to publish them through, just so that way we have the right personnel if they're just objecting to us publishing them?
I mean, they're admissions.
They're admissions by a party. I don't know that I need to do it through a witness. I obviously don't have the witness who wrote them to publish them. So if we're running out of trial days, I just didn't want to get in a situation where the plaintiff's going to object to the publishing. If they require them to do it through experts, then I'm happy to recall experts.
We'd like some consistency here. We've heard repeatedly throughout this trial objections to us publishing documents unless they're through certain witnesses. We've heard repeated objections. They're out of context. So if we're free to publish party admissions out of context, I'd like to consider it with Mr. Anderson and get back to them in the morning.
I'm trying to remember, because I know the defense has raised that identical objection. I'm trying to remember how I handled it.
Judge, I know that there was at least one thing that was published to the jury, because I was going, there's no context, and you said it's in evidence, and then they published it. So I don't recall what it was. I don't know if it was a policy or what exactly that was, to be honest.
Was that the one right after a video dep?
I honestly.
Because I remember doing a couple right after a video deposition, and I don't remember if those were exhibits that were referenced in that deposition or if they just were freestanding, and I just don't remember.
I think they were just freestanding, Judge, because I remember losing the objection, but in all honesty, I couldn't tell you what it was at this time.
You won't be surprised we have different memories of that.
Well, again, just because I know that we have to give them 24 hours notice for what witnesses are coming, assuming they don't want us to be calling witnesses into Wednesday.
I'll tell you in a second.
We would just like to know who they would require. I just don't want to have Dr. Crane come back by Zoom, put them on in front of him. If they don't want us to just publish them without a witness, I'm happy to call a witness, but there's obviously only so many witnesses I could do in contact.
Are you talking about doing all of the ones I admitted yesterday?
There's so many of them, no. My plan today would have just been to publish 2 and maybe 3. It would have taken 10 minutes of our case to do so.
Is it 2 and maybe 3 and that's it, or is it 2 and maybe 3 at intervals going forward?
Probably 2 to maybe 3 intervals going forward. We only have 4 trial days left, so that would be 10 minutes of publishing per day.
I'd like to discuss it with Mr. Anderson and see what our position is going to be.
That's fine, but let's come to a final resolution in the morning on it. I mean, obviously it's preferable to do it with a witness, but if they are in evidence, ultimately they're in evidence.
Understood.
What's next? Are there other exhibits that we're needing to go through?
Okay.
I mean, since we've found ourselves with a few minutes, might as well try
Sorry, I was
to
packing up. Let me.
The ASMR
use the
zipper
time efficiently.
segment has started now. Everyone get cozy, put your
And
headphones
since
on.
there's not a further witness
there it
today, the shot clock stands today. Plaintiffs consumed 1 hour, 20 minutes, and that places you at 54 hours.
That's 5 hours left.
The defense consumed 2 hours, 30 minutes. That places you at 33 hours. 24 plus 9 is 33, yeah. 33 hours.
Okay, so our math was almost exact. Our stopwatches are synced with the judges.
You ready, Judge?
Yes, ma'am.
So I would like to, and I appreciate this is another email, but it's a different time frame that's what's in. It's 32320141, and I think we have an edited version that just contains Beata Kowalski's Facebook post. But it's October 12th, 2015. I had a chance to look at the emails that the court has allowed in. This is the only email that addresses this. This is her description of the ketamine treatment that she was undergoing with Dr. Kirkpatrick. 32320141, and I believe you edited it so that it only had, I have a hard copy here.
Gary, good catch. There were 2 notes of muscle spasms in that last note, both in quads and after knee flexion.
Well, that's too edited.
The entire page is blank. It's fully redacted.
That's 3231, not 3232.
Oh, yeah, I need 3232.
Yeah, defense has used 33 hours. The plaintiff has used 54 hours. So plaintiff has 5 hours left for a total of 59. And then we could do the math.
There we go.
On the other side as well.
So, Judge, this is
26.
Dated October 12th, 2015. And if you look at the description, it is her description.
Can you make it a little bit bigger? Thank you.
Of the ketamine treatment that she's undergoing with Dr. Kirkpatrick, describes how it was, describes the hallucinations that Maya experienced. And it goes on to the next page.
Well, I need to finish.
I have a hard copy, Nick, if you can pick it.
Next page, please.
And this was edited to end at, should be edited after the top, after the top paragraph. We would delete the rest, which I thought had been done. So this is the only description of the ketamine treatment with Dr. Kirkpatrick. The other emails started after this, Your Honor.
Whenever you're ready, Mr. Whitney.
We object, Your Honor, based on the court's previous statements about the number of emails that have already been let in. We object on 403. We object on hearsay. And we also reiterate that this goes to none of the pending claims. I think the court's still waiting on a response on Fabre. And as the court pointed out the other day, however Maya presented at the hospital on October 7, 2016, you don't go back and recreate the accident to figure out what happened a year prior. So there's no relevance to this email from our perspective, or Facebook post.
Judge, this goes to the concerns that the doctors had with regard to the amount of ketamine. It also goes to dispelling the presentation that's been given to this jury by Dr. Kirkpatrick, that this was very safe, that there were no issues, that it was not a problem. Clearly there was a lot of issues during it, as described by Mrs. Kowalski, who was there.
Then the last reference to the GoFundMe.
Well, that's we can take that out, Judge. I mean,
the exhibit, with the exception of the GoFundMe, I'm fine with.
Okay, so we'll end it. We'll take out 4 more updates and the remaining sentence.
Let's make sure the clerk gets a printout of the updated exhibit.
Okay.
What's next?
Let me just make a mark to it. My just and 3309. These are Dr. Patrick's billing records.
3309.
3209. I'm sorry, 3309. It's on the,
How many pages are we looking at?
8.
Just go ahead and scroll next page. Next page. What is this? We're on page 3. What is this?
Page 3.
So just got off the phone with a viewer who says that Sally Smith was involved. This is what the viewer said. Sally Smith was involved in a conference during this trial, talking about this trial.
What is page 3?
Presentation type between sessions about Munchausen by proxy.
What is page 3?
We're trying to get some more information on that. But that might be a problem.
It looks like the health insurance claim form, Judge, but I'm not sure why.
Next page. Next page. Next page. Next. Next page. Next page.
That's last page.
Can you go to the first page, if you don't mind, now? And the next page, too.
I haven't been following chat. Is everyone being good?
So we're going to withdraw it. I don't think it makes sense.
Amber, we might need your help on this one to chase some stuff down.
What's next?
Come here, 1 second, Judge.
No. Okay. That's fine.
Judge, just for the record, can we go to 3023? So I'm not sure if the court's rule on these. I understand this is Arnold Palmer hospital records, and I understand that Your Honor has not allowed the testimony of Dr. Alexander. We went over that yesterday, I believe it was. These are the actual records, so I wasn't sure if the plaintiffs are objecting to all of these records going in or just the records with the statement that mother states, etc. Does Your Honor recall the issue? Am I being clear?
Give me a little bit more.
Sure. We wanted to play the deposition of Dr. Alexander, who had the history from the mother that she states that she was injecting ketamine into her report. Your Honor, it did not allow us to present that testimony. These are the records from that visit, which obviously include more than just that one statement. So we wanted to put the records in. The records in. Understanding that statement's in there, I didn't know if the court was going to require us to redact that, or if none of the records were coming in, and I wasn't sure of the plaintiff's position.
We'd be fine with the redactions, but it'd be a 403 issue without the redactions. I think we've discussed this at length.
Well, what we discussed was the deposition. I don't think I discussed the records, but the concept of IV ketamine at home needs to come out of these records if they exist in there.
They do, Judge. That's what he was testifying from, and he was testifying from the history he took that is in the records where it says mom states that she is giving, I don't remember the exact quote, but ketamine at home.
I still maintain there's a significant 403 issue with the concept of the ketamine via IV at home issue that has been discussed for years. So that concept, if it is out of the medical records redacted, then I don't think
so we will look at the record and did you?
I was just going to say there's actually two doctors in these records that say more or less the same thing, so we just need to make sure we get both sets redacted.
We will redact based on the court's rulings and then show it to counsel and go from there.
Thank you.
I'm going to answer these questions in just a minute.
Okay. Um, 3080. 38.
Just exhibit 38?
I was going to ask her. It's a video.
Yeah. Aren't they 4 digits?
I'm sorry. I thought I said 3080. 3080. I don't have that. You don't have it? Okay, let's get that.
Oh, 30.
Yeah, sorry.
So you don't have that 3080?
No.
Okay.
This, for the most part, is minor paperwork. So far, I haven't seen any smoking guns they're trying to slide
I'd like
in.
to address 3217. These are going to look familiar to you, Robert. It's 570 to 574. So 3217, 570 to 574. I don't believe that we've ever resolved the issue. We've discussed them a couple of times. These are the emails between Beata and Charlotte Laporte. This is the last time I tried to bring it up. Your Honor said, "Wait a minute, aren't there 4 pages?" And I said, "Let me get that, and we'll come back." These are the 4 pages, Judge. I think the plaintiff wanted all of them in, if any went in. They start backwards, so you may recall them. They start on the 573 would be the first one. It's a November 15th email from Beata to Charlotte Laporte at 9:25 in the morning.
Well, it looks like there's something before this.
Number 4 is just thank you. So,
Yeah, go to 574 so the judge can see it, if you don't mind.
yeah, that's just the end.
Welcome to Brandy Churchwell and the 13th jurors. Thank you so much for rating us.
And then it is Ms. Laporte's response on November 16th at 10:39 a.m.
Can you go to the 572 page?
Kathleen, I don't have hard information yet. I just got word of something that could be very big in this trial, and we're trying to chase down information on it right now. And it involves Sally Smith and a conference that was going on during this trial.
Can you go back to 573? Go back to 572. I guess I need to go to 571 now. Back to 72.
To the individual who shared that information with me, and you know who you are, is it okay if I share your contact information with Amber, one of our document hounds that has to chase this down a little bit?
Back to 71.
If you can just text me. I'll just text
Go
you
to
directly.
70. Um, 71. I've reviewed it, so now what is it that you are seeking to do?
I'm sorry?
What is it that you're seeking to introduce?
Well, I just wanted the one email, but the plaintiff wanted all of them. So I'm seeking to introduce all of these, Judge. First of all, the communications by Charlotte Laporte are done from her business email. They are a business record. It's her communicating to Ms. Kowalski in the scope of her employment and role with DCF. So I think that those emails are business records. These emails by Beata are admissions. She's admitting that she was told that she had restrictions. She's admitting their statements of the party. So I think her emails come in. She admits she didn't read the rules. She admits that she was told to not do certain things. She acknowledges that she will try to follow the rules in the future. Charlotte reports emails also a prior consistent statement when she was testifying with regard to being the person on the November 15th, 2016 call that was played for the jury where she redirected Ms. Kowalski. So they believe for numerous hearsay exceptions, they also are plan of action, and they're not hearsay. So we believe that they, for multiple reasons, are admissible.
Everything Ms. Krause just stated applies to Trial Exhibit 2123-610. This is the email from Kathy Beatty, party admission, to Charlotte Laporte at her business account that was previously excluded regarding the phone calls. That was excluded. We argued over that strongly. If this comes in because it's a business account of Charlotte Laporte and it's a party admission, then 2123-610, we move for reconsideration.
Well, I don't. Y'all have agreed to that these are authentic.
Yes.
That doesn't mean the hearsay exception for business records has been shown or demonstrated. So I don't see where there would be a hearsay exception that would apply for Charlotte Laporte's statements.
Well, Your Honor, we can recall Ms. Laporte then to testify regarding this is her email, or business email. It's just the normal way she conducts her business and how normal way she communicates with persons that she needs, parents that she needs to communicate in her role as a DCF employee, if that's the issue.
What is it that you're trying to get and use? Let's look at it that way.
Sure. This is, there are issues in this case that the plaintiff is raising with regard to, first of all, this phone call. They have testified was Ms. Beatty on the call. We called Ms. Laporte, who testified it was herself. This is confirmation that it was her on the call because she's telling Beata, I had to redirect you on the phone call. So it's referencing that same phone call. That's why I'm saying it's a prior consistent statement. Also, plaintiffs are taking position and making a claim that to the extent Ms. Beatty redirected Ms. Beata Kowalski on phone calls, that was inappropriate, and disregarding the issue of whether she had authority to do it, this establishes that what she was redirecting her from are the same things DCF said you cannot talk about. You cannot talk about pain. You cannot talk about the case. You cannot talk about her therapies. So it's confirmation that Ms. Beatty was redirecting her to the extent she did in line with the guidelines that were set up and established with this first phone call by Ms. Laporte on behalf of DCF. So it goes to numerous issues that the plaintiff is attacking the defense for doing, including the identity of who was on that call that they continue to maintain despite Ms. Laporte's testimony that was herself.
Well, the jury doesn't believe her either, but that's a different issue. Your Honor, this is fundamentally sword and shield. They want to focus on the November 15th phone call because of these emails. And then we want to raise a November 29th phone call where there are party admissions by Ms. Beatty, and they want to duck back behind DCF in that instance and say, no, the November 29th call, we can't talk about that. We can talk all day long about the November 15th phone call, put emails in about that. But we can't put in emails about the November 29th call. Ms. Beatty is clearly here saying, I'm honored at the call, and I have all sorts of issues with the way that was conducted.
Judge, the November 29th...
Let's just put the November 29th so I can look at it again.
Yes, to remind the court, the November 20th... I don't know the exhibit number.
2123-610, please.
The email they wanted in was communication regarding recommendations being made to the court. That is opening up the DCF action. This goes to a disputed issue of fact in the case that they have raised, calling Ms. Laporte essentially a liar for testifying that she was the one on the phone call.
Again, this is not an email to the court. This is an email from Ms. Beatty to Ms. Laporte, just like the one you just saw, Your Honor. This is the same exact circumstance, except instead of being Ms. Kowalski, it's Ms. Beatty.
Here's where I'm at. With respect to what we're looking at now, which is 2123-610, I continue to maintain that that is out. It goes to a Chapter 39 issue, which is a request from the hospital to change the dependency court's order. Going back to the other one, there is no exception to the hearsay for purposes of business records. That foundation hasn't been laid. Now, the statement that that Charlotte Laporte said with respect to who was on the telephone call is a prior consistent statement, which for that small portion is supported by a hearsay exception. So that portion can come in. It goes to a specific issue in the case. Now, let's pull that email up and see if there's any fair way to redact it.
3217.
Well, it starts with, I found no objection with your phone call.
We're looking at a way to clean up this document so they can fairly introduce it, because there's part of it that is admissible.
Also yesterday when you were on the phone, I had to redirect due.
Yes.
Let's see the next page.
Susan, I did. We're looking into that. We've got all sorts of information on that. Apparently, one of our members here was at a conference where Sally Smith was present and participating, talking about Munchausen by proxy, is what I'm being told. So we're trying to verify the dates. We're trying to verify some information here.
Mr. Whitney, at this point,
let's see what that means.
Thinking of just letting that one sentence in. I mean, obviously the header saying who it's from and who it's to.
In the future, if my happen, which
Can you put 572 and 573 up together?
In which sense? I'm sorry, Your Honor.
Okay, down on 572, where it starts with also yesterday.
Understood. And so
we would redact out everything after hello Beata until you got to also yesterday, and then the next sentence in the future, that to Ms. Laporte's signature line would be redacted.
But we're redacting in the future?
So, Your Honor, if I go back to understanding where the court is with this, I go back to the position that we discussed, I think it was last week, which is it is prejudicial to us to only include Ms. Laporte's communication in this regard. So if this 4 pages are coming in piecemeal fashion, then that Beata Kowalski's communications regarding her compliance, her intended compliance, her notification that she didn't get the rules because she sent them too late, etc., also come in.
Well, what I was going to say is that one sentence, I think, is supported by a hearsay exception, which is a prior consistent statement. Now, if you want under a rule of completeness theory all 4 pages, that's a different issue.
Yes, we would, except I think there are issues with, perhaps, I haven't sat down with this email, but I think there's probably issues that still wade into Chapter 39 territory. So rule of completeness maybe with certain redactions. But if we're going to let this in, we request the entire exchange come in under rule completeness.
That's fine, Judge.
Well, then why don't you look, Mr. Whitney, to see if there's anything from a Chapter 39 perspective that can be selectively redacted. Okay.
You mean tonight or now?
I think tonight.
Yes, Your Honor, I'll do it.
Because this is something for tomorrow?
No.
Well.
Okay, we'll do that. Thank you.
Thank you. But I'm giving you the choice of just having that one sentence or the balance of it. What's next?
Do you want to do more?
Let's go another 10 minutes and then let's call it a day.
We want to do our depth objections. All right, let me see. I don't think there's anything.
Okay, 3080 is ready.
Oh, 3080 is ready, Judge.
3080, let's put it up, please.
Hold.
And just like that, that's how YouTube hits you with the copyright strike, guys. You just watched. You just watched it happen live. Oh, Maya, I love you. I love you. You're killing me. Oh, my goodness. I was not paying attention. I was not paying attention. So it's all right. I can sing along. I don't know this song, actually. But the choreography is fire. She dances better than I do. I'll admit that right now. Generally, what happens on something like this is the copyright holder usually on something like this does a copyright claim where they say all revenue from the video gets transferred to the copyright holder because they have a copyright on that song. And so let's see. I think we're done with that one.
Music video.
No.
The one that the plaintiff put in?
July 2016.
That's enough music videos. So this one's cumulative.
Thank you, Judge. That saves us. This is great news. Dr. G has his video up about this case. He was on here last night talking about this.
I don't recall what happened to 3054, 116. The plaintiff had an objection to page 609. And pardon my short-term memory loss, but I don't recall if the court ruled on page 609 of their objection. It was the one that had the various, it had the various comments.
I'm not sure which.
Put it up in
It's the Venice High School, page 609, that had the various, you objected to the one page. 3054.
Okay, can you give us the number again? The clerk wants to know the number.
Sure, I'm sorry. 3054. And then it says it's page 609. But I think that was the Bates number we figured out.
ID only, okay.
Okay. So this was the one, yes.
Oh, this is the one where I was wondering whether RN is actually the initials of a person as opposed to a nurse.
Yes, I just didn't know if the court had ruled on this. I didn't have any notes.
I have not let it in.
Okay, so that's fine. So for the record, 3054, the objection is to page 0011, and the court is sustaining that objection. Is that correct?
I have not let it in.
Okay. But my understanding is the rest of the exhibit is not objected to. Is that correct, Mr. Wayne?
I haven't looked at the rest of the exhibit. Is it grades? If it's just grades, we don't object. If it's other counseling notes, we may object.
You did previously say page 609 objection only.
Well, what's page 12? And what's page 10?
Yeah, the rest are just grades.
I think the rest are just grades.
I mean, on the proviso, the rest are just grades. We don't object.
Can someone just check that before I...
We'll check it before the morning, Judge.
Officially let it in?
Yes.
You have 5 minutes left. Anything else?
I'd be left real quick, please, Judge. I think, yeah, I need to, based on, of course, rulings, I don't want to take the court's time up and look at some photos we had to make sure we're just going to remove.
So that's where we're stopping today?
Yes, sir.
We found a stopping point.
We're going to start 15 minutes later, so 8:45 tomorrow, 8:45.
So that means 8:30 for us.
Okay?
Yes.
We'll be in recess, 8:45 tomorrow.
Okay, the judge is headed out. We are going to head right here. 8:30. I'll just make my notes so I know when to start tomorrow so we don't miss it. All right, you had a couple questions on here that I wanted to cover, and we're going to dig into the Sally Smith thing. It might not be anything. We'll try to dig into this a little bit and see if that's an issue or exactly what happened. But let's see. Let me turn this off right here. Wait, I need objections. Sorry, I need to show these. 2 is going to be 4. Let's take that to there. Cut. All right. Objections were at 14:01. I need to put up and show you where we are on the counter. Then I'll answer some questions for you regarding where we're at. Counter is, let's scroll down just a little bit. Forgot I can't see it over that screen. I'm going the wrong way. 14:01. I don't know why the numbers go backwards sometimes. Okay, there we are. So 14:02 is Betty Gorley. 1400 is Jenny and GA. So we're coming up on a few people here. Classy Girl, Lorianne, Darren Cousins. That's where we're at for the day right now on the guesses. All right, turn those off, and now we'll go about where we were before before we got the copyright strike. I'm not sure if we did. We did get hit with the copyright strike from Megan Trainor earlier in this, a copyright claim, I should say. It's very important to say this. A copyright claim from Megan Trainor from the previous video that Maya was dancing to, the music video, with about as much time. I was not paying attention at that time, so I expect we'll probably get a little notice that we might have to edit a little bit of audio out of the video. Usually that's the way we can fix it, so it's not a big problem. Hopefully. That being said, let's see. Had a couple questions. First of all, a lot of you were saying why we had a deposition that we said, haven't we seen this before? And we had. That doctor with the blue background, we had seen him before for about 2 minutes, and then they said, wait, hold everything. The plaintiff wanted to rethink their designations and cut it down because they had way too much time spent on that video. So they were going to say, we don't want as much played for us, billed to our time, so we'll cut it down. So today they start playing it again, and it's been cut awfully. It's brutal. It's chopped up all over the place. And then this time, I said the plaintiff did that. This time the defense said, wait, stop. It's playing stuff that we didn't want. We don't know why it's the way it is, or maybe there's parts that the defense said to cut out, or the plaintiff said to cut out that hadn't been cut out. Anyway, whatever it is, it's going to get shorter. It probably will be replayed. So we'll get to see it a third time, but that's where it goes. Shannon, it's okay. We'll deal with the issue. We've come across it before, and it's not the first time, but that's good. Designations. A designation, as we've talked about, is when one side says we have a deposition that we want certain portions of it played. We're designating that we play these portions, and it might be the other side that asked the question. It doesn't matter who asked the question. It's just whoever highlights it and they says this is the part we want. That we add up all those highlighted parts, all those designations, and that's what is charged to that side. And then you play both highlighted parts. So everything that the plaintiff wants and everything the defense wants might be put together, and then they play through the whole thing, and then they account for the time from that. So that's the designation, and that's why the depo was stopped a second time. We saw from the judge, we got the shot clock at the end of the day. The plaintiff used 1 hour 20. And once again, he's over an hour. We have a week of trial left, okay? And they have 5 hours. And we've got Sally Smith tomorrow. 5 hours. So crazy on that front. The defense has used 2 hours and 30 minutes. They have 33 hours into this. So they have 26 hours left. Is that right? 59? Yeah, 26 hours left for them. Why play a depo of Beatty and Sally Smith and then call them to the stand? Well, the plaintiff played the deposition, and a deposition or in person, it's the same thing. It's considered the witness testifying, even though it was filmed prior to this. The only difference for us is that the jury doesn't get to ask questions at the end. But for the jury, it's still considered testimony, just as if they were in court and sworn under oath there in front of them answering the questions. So they can use either one. They might have got questions they really like. I mean, they were under oath the first time as well, but they might have had a response that they really think the jury needs to hear in a deposition, and they're not sure if they'd get that response, on the stand again. So they can make that choice. So the defense here is calling Kathy Beatty and Sally Smith, where the plaintiff brought their video depositions for both of them. The defense at the very end tried to get in a few docs that specifically one that had some record. I think it was Beata's Facebook page that might have made mention of her administering medication through a port. They're trying to get this in. They think it's very important to their Munchausen by proxy claim to show that Beata was giving these harmful drugs to her daughter. The judge has ruled that out, and then they fought over a few other documents. Honestly, I was a bit distracted, and I didn't hear exactly what those documents are, but it didn't sound like it was really major as far as shifting the whole direction of the case. Okay, we've got the standard jury instruction. I thought they were going to read that today. The judge said he was going to. At least I thought he said he was going to, and that was regarding what happened yesterday, where at the end of the day, Mr. Anderson and Cross had crossed a witness and basically hit really hard, or actually it was right before lunch, right? He had hit really hard on the fact that this witness had met with the attorneys, and how long and how often and what did they give you and everything else. Almost as, and to the defense's case, point, they said, we want you to read the instruction that it's okay. It's okay for us to meet with to meet with these witnesses and to prep them for testimony. It's okay to do that. And so that jury instruction will be read at some point, maybe at the end. I thought it was going to be at the end of today. But you can expect to hear that, where it's perfectly appropriate to talk to their lawyers. Sloth Life, welcome to the gallery. Thank you so much. Welcome. Good to have you here. All right. Thanks to all those who came from many different channels and rated us today. It's wonderful to have all of you together. This is the most amazing community. It is so diverse. Honestly, we've got people in here that everything from patients to doctors to lawyers, police officers, you name it. We could do a roll call and there'd be people raising their hands across this whole spectrum. And what that brings is when topics come up that a lot of us have questions on that we're not well versed in. We have great people in chat that can help us out, and you guys have been doing that all day long. Thank you so much for that. Danny Austin says, 6 months on this account, 6 months on my other. Does 12 months make me the longest member? Best year ever. Danny, thank you very much. And to your significant other, good to have you here. Longtime supporter of the channel. Let's see. Just Joy, welcome. I do try to make audio a little better than what we can find on other feeds. I've got some crazy audio gear that helps me do that. So that might be why you heard about me. I am not a lawyer. For those that are asking, I am not a lawyer. We have many great lawyers in YouTube, in LawTube. Some of them have white flowing hair that is gorgeous, and other of them have even better looking hair, like the lawyers you know. I'm sorry, Ian. The lawyer you know wins the hair battle. That's all I'll say. I love Ian from Runkle of the Bailey, but I think Peter Tragos wins the hair battle when it comes to that. Rob, thank you very much for your input. I know you're on trial prep right now, and he's been texting me and giving me a little bit of advice and things and answers as well. I appreciate that. Let's see. Any other questions we have to answer about court today? I'm sure when jurors are done with their civic duty, they'll be entertained and perhaps enlightened by the increased interest and conversation on the internet regarding this case. I imagine they'll be blown away by. I mean, a lot of times people go to a trial and it's huge, it's traumatic. It's like, hey, it was a capital punishment trial, and it was, we had murder, and we saw all these awful pictures, and they get out and all their friends have no clue what happened. Right? They're just like, oh, that was Was that happened this week? And for them, it's like life-changing experience to sit as a jury member hearing all this evidence. And then we have cases like this where these jurors come out and they find out the whole world is talking about their trial that they were sitting through. And they haven't been able to hear a word of it because they can't check any media about this. Okay. I'll have to replay the last few minutes to see what's up with Smith. He had a text to respond to. Sally Smith is expected to be in court tomorrow. And that is going to be really, really good. And it's definitely going to be one of the witnesses that the plaintiff wants to cross-examine with the 5 hours they have left. But I don't know, all these depositions they're playing is just eating away time as well. Ashley, I've been talking to Rob about the Sally Smith stuff. He's helped me some clarification. He thinks he's told me that the main issue would be if she is talking about having watched the trial. That would be more of a factor. I mean, the fact that she's going to a conference and learning about things as a medical professional, you can't just stop your job and not talk to anyone while you're in a trial that lasts for years. So that in and of itself isn't bad. We just have to find out more details about the actual event and what the conversation was. So we're looking into that a little bit. Jules mentioned that both sides asked for more time. Did they get it, or do we know yet? Jesse, I didn't catch that. If they did, it might have been very quick. I don't think the judge awarded any more time as of right now. Kathleen says, what was the big deal that people were saying a judge should know about? That's something we're looking into about Sally Smith and a conference involving Munchausen by proxy that was occurring during the trial. And apparently there was some conversation about the trial at the conference. It's behind a big paywall, so we'll see what we can find. I think she was learning. She was not speaking. She was not a speaker. She was a participant and possibly remote participant, but there was opportunities to converse between presentations. What I'm hearing is the questionable activity happened right then. Does the jury know about the time limits? I think they've caught on. This jury is very quick, and there have been many times where the jury's been present and statements about remaining time and in the interest of time, and we'd like to, but due to time constraints, we can't. Those things have been said, so I think the jury knows there's some sort of time constraint. They obviously know the drop dead date as far as we will be done by this date, which was the 9th of November that the judge gave them. They know that, but I'm not sure if they're aware of the stopwatch that is running in the background at all times when they're in the room. Let's see. All right, I think that's all. What are your thoughts about today? Oh my goodness, this trial does not ever disappoint. I love watching good lawyering, and we have fantastic lawyers on both sides. And I realize some people will watch this and I'm like, oh, I can't stand when they complain. Why don't you just drop it? They're doing their job, and they're doing it very, very well. They're neither side. The customers, the client on either side has any reason to complain about these lawyers. They are doing a fantastic job under tons of pressure, and it's for all the marbles. I mean, this is a big deal. Of course, it's going to go through appeal, and anything that happens here will probably get morphed a little bit before it ends in its final state. But I think they're doing a great job. I love it, and it's spicy. It's surprises around every turn. Just quality crossing, the objections, the need to be right there on the spot and to be able to object with the right objection at the right time. That's pressure while you're doing everything else at the same time. What time are we coming back tomorrow? The judge says they're starting at 8:30, which means we will start at 8:15. They'll have approximately 45 minutes of paperwork. So if you're late, it's like the opening credits. If you don't like the paperwork, the stuff we saw at the end of the day, talking about video designations, about admitting different items of evidence and arguing back and forth. If you don't want that, which I think you should watch, because a lot of this trial, the big battles are fought in what evidence is allowed in many ways. So that's very telling. But if you don't want that, you've got a little bit of time before we actually get to testimony. But I would not be too late, because Sally Smith, Sally Smith, need I say more? It's going to be a fantastic day tomorrow. All right. Goodman Law says, I doubt Sally Smith or Beatty are coming. Counsel wants plaintiff to waste prep time on them instead of the other evidence. It's a tactic. I don't know. What more impactful witness would they possibly have that they would use Sally Smith or Beatty as a distraction for? They've already brought a star witness with a doctor. They've brought a stellar nurse. I think we're going to see, as far as the other witnesses, we're going to hear more people that are saying the same thing from a little different angle. But I think these two, they need to get some testimony out of them that will support what they did. And they both stand by their actions 100%. So I think defense has to call them. I don't know. My money's on them showing up. And I think they're local, so I think they'll be there. They're under subpoena. All right. Member of this chat mentioned it earlier today who saw it but could not record it. Right. We've got all the contact information. I've got all that, and we've got some of our document hounds chasing things down. If there is something, there are ways to get information to different counsel. Obviously, the counsel cannot talk to us about anything, so they might. It's like talking into a phone where they just nod on the other end and they say thank you and hang up. There would be no inappropriate discussion anywhere, and it's perfectly legitimate and fair to do that. It's not a problem. There's nothing. K-Cat says there's nothing Beatty and Smith can say that won't make the jury hate them more than they already do. I don't know if they hate them, but I think the general consensus, at least if we are indicative of what the jury is consisted of, a lot of disagreement with what they did would be present. But man, they need 6 people and unanimous decision, so it just takes one. All right, I think we're going to end. Other great people are starting some amazing live streams. I think Lawyer You Know, is that one right there? Andrea Hills, Lawyer You Know. There you go. All right, we're going to play some music and tell everyone it's time to go home and turn out the lights. It's been a wonderful day. Thank you so much for being here. Watching this with you guys is the best. It's the best thing ever. Thank you so much. It would not be the same without you. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again. It'll be tomorrow morning at 8:15 as we continue. Sally Smith will be here. If you have to call in sick, if you have to take a day off work, you might want to consider doing that now. It's going to be a great day. Fingers crossed. Sally Smith tomorrow. So thank you guys. Appreciate all of you. To our amazing mods, thank you so much for all the work. It's been a lot of work today. You guys have handled it stellarly, if that's a word. It is now. Thank you. We'll see you guys tomorrow. Have a good one.